Yes, sir.
All right. It's 2:33. We're back from lunch. The live stream and everything's on. If you all, Mr. Masterson, I know you all are dividing things up a little bit. Are you going to keep going, or is it Mr. Bohr's turn?
You know, I am becoming more self-aware as I get older, so I thought we'd break it up a little. To preview it for the court, subject to the court wanting something different, we were gonna, Mr. Bohr would address Dr. Alter, and then we'll take Bowie and Persinger just to kind of complete all of the non-medical people, and then do the medical motion last.
Okay.
Okay.
And we're in agreement with that.
All right. That sounds great. All right. Well, Mr. Bohr, the floor is yours.
Thank you, Your Honor. Your Honor, we've got a couple of slides on the PowerPoint that are queued up.
All right. That'll work.
All right, thank you very much. Your Honor, Dr. Adam Alter has ideas and theories on the speed filter. We prepared a slide with a summary of his opinions in this case, and this is what he's intending to testify to the jury. He wants to tell this jury that Snap knew or should have known that the speed filter would encourage dangerous behavior among its predominantly young user base, that the demographic characteristics of Snapchat's user base increased the likelihood that users would use the speed filter to enable dangerous behavior, and that Snap stood to benefit from the speed filter and accordingly had an incentive to continue offering the feature despite that concerns that it might promote dangerous behavior among Snapchat's user base. Now, this is the theme of the plaintiff's case against Snap. But Snap must move to exclude Alter's opinions in this case and prevent him from testifying before the jury in this case, because these theories are not based on sufficient data or facts. And I want to first discuss for the court the law that's relevant to this court's role here, which is extremely important. The court's role as a gatekeeper, that is to exclude unreliable and unhelpful testimony from unqualified witnesses. Next slide, please. This court must exclude unreliable or irrelevant testimony. We cite from the Scapa Dryer Fabrics Inc. versus Knight case, 299, Georgia 286, 2016 opinion. Generally speaking, a trial court must assess three aspects of proposed expert testimony: the qualifications of the expert, the reliability of the expert, and the relevance of the testimony to discharge its responsibilities as a gatekeeper. Next slide, please. The court is required to analyze an expert's methodology. The Daubert Ninth Circuit opinion says that the party presenting the expert must show that the expert's findings are based on sound science, and this will require some objective, independent validation of the expert's methodology. The United States versus Frazier case, 11th Circuit opinion, says that the trial judge must assess whether the reasoning or methodology underlying the testimony is scientifically valid, and whether that reasoning or methodology properly can be applied to the facts in issue. Next slide, please. Your Honor, expert testimony must be derived from the scientific method. Daubert says, in short, the requirement that an expert's testimony pertain to scientific knowledge establishes a standard of evidentiary reliability. And also says, in order to qualify as scientific knowledge, an inference or assertion must be derived by the scientific method. Next. Last, testing, Your Honor, is what separates the theory from scientific knowledge. In the Nice versus Ford Motor Company, the court said that one especially important factor for guiding a court in its reliability determination is whether a given theory has been tested. According to Daubert, a key question to be answered in determining whether a theory or a technique is scientific knowledge that will assist the trier of fact will be whether it can be and has been tested. In their response, the plaintiffs in this case are telling this court that as long as Dr. Alter is qualified to testify, then everything else should be for cross-examination. But that isn't true. And it's especially not true in a products liability case. In fact, that's what the case that the plaintiffs rely on in their briefing, Cotton versus Phillips, says. In their response brief, they cite the Cotton versus Phillips at 280, Georgia Court of Appeals 280, 2006 case. This is a medical malpractice case. And the court there said, well, Daubert's not served by excluding testimony supported by relevant experience. But the plaintiffs, they didn't cite or quote the next sentence of that opinion. All right. The next sentence is the important part for us, Judge, because the next sentence says, such exclusion is rarely justified in cases involving medical experts as opposed to experts in products liability. This is a case that's been interpreted by the appellate courts to be a products liability case. Dr. Alter cannot be permitted to testify in this case where he never analyzed, tested, or otherwise applied any scientific method to his findings. Dr. Alter never subjected his findings to peer review or publication, and so there is no information on the known or potential rate of error for his findings. And there is no information on whether his technique is generally accepted in the scientific community because he doesn't have a technique. Next slide, please. Dr. Alter's first opinion is that the speed filter caused Snapchat's users to drive dangerously. Now, Alter cites no evidence whatsoever that the speed filter caused any driver to drive dangerously. There's no studies or literature finding a causal link between the speed filter and dangerous driving. There's no testing or analysis finding a causal link between the speed filter and dangerous driving. Alter's central claim is that Snap knew or should have known that the speed filter would cause dangerous driving. But that central conclusion rests on a missing premise. There's no evidence the speed filter caused anyone to drive dangerously at all. Alter identifies no study, no data, no testing, no real-world analysis showing that the speed filter increased dangerous driving, much less that it caused the accident at issue here. And he freely admits it in his deposition. Next slide. At page 296 of Dr. Alter's deposition, we asked him, of all the people that experienced any influence from the speed filter, do you have any opinion as to what percentage of them acted on it and drove fast, too fast, or recklessly? And he said, my opinion is restricted to the fact that this globally increases the likelihood that it will happen, but not about the percentage of people who do or do not respond to it. We asked, I mean, in terms of whether it's more or less than 50% of people respond to it or not, you don't have an opinion on that? He answered, it's not something I sought to examine or quantify. He says Snap increases the likelihood people will drive dangerously, but he didn't actually look to see if more people drove dangerously. The plaintiffs argue, well, how are we going to do that? Alter's opinions, they can't be tested. And okay, well, that doesn't change the fact that testing is required to change a theory from theory to scientific knowledge. This is a theory. He has a theory that the speed filter caused or increased the chance that people would drive recklessly. He hasn't done the testing or the analysis to turn that theory into an admissible opinion. Next slide. Dr. Alter says at page 244 of his deposition that there's a lot of reasons why somebody might drive fast. We asked him if you compare incidents involving teenagers speeding and causing traffic accidents from 1950 until now, do you have any basis or belief that you reviewed that to say that there's even been an increase in accidents caused by speeding teenagers as a result of any social media application? And Dr. Alter answered that dangerous driving is multiply determined, which means lots of factors lead to it. And so I wouldn't have tried to conduct that kind of analysis and tried to pinpoint the speed filter as the cause of any rises or declines. Dr. Alter did not do any analysis whatsoever to determine if the speed filter was the cause of any rise or decline in dangerous driving by anyone. Alter takes it as a given that the speed filter caused people to drive dangerously. But there are no scientific studies or publications on this point. It's not just Alter. No one's ever performed any scientific testing or analysis on this point that's been identified to us. And certainly none's been identified to us prior to September of 2015. There is no scientific testing or analysis of any connection between any social media platform and dangerous driving. Setting aside scientific studies, analyzing whether the speed filter had an influence or a causative impact on a person's decision to drive dangerously, Dr. Alter has no statistics or data whatsoever regarding how many people posted photos or videos misusing the speed filter. He's got no statistics or data on how many people were speeding before, during, or after the speed filter was available on Snapchat. Instead, Dr. Alter extrapolates from general observations that he makes about teenage risk-taking. But not one of the articles or the papers that Alter relies upon mentions Snapchat or even social media at all. These articles are not a study of Snapchat or dangerous driving. The articles that Dr. Alter relies upon from before the date of the subject crash simply conclude people like round numbers, and teenagers might take more risks than adults. Alter then, on his own ipsy dixit, makes the analytical leap to opine that the speed filter caused people to drive 100 miles an hour. Dr. Alter has a theory, but he didn't test it, and no one has. That's not the scientific method. Next slide, please. The Davis versus Lockheed Martin Corporation, it's a Middle District of Florida case, 705 Federal Supplement 3D, 1345. Court said, the courtroom is not the place for scientific guesswork, even of the inspired sort. Law lags science. It does not lead it. Dr. Alter cannot testify that Snap knew or should have known that the speed filter would make more people drive dangerously when he admittedly does not know if more people drove dangerously. It's also important to note that Dr. Alter's opinion is not relevant. What is relevant in this case is whether Snapchat proximately caused the crash in this lawsuit. In other words, did the speed filter make McGee drive too fast and get in a crash? Dr. Alter didn't review McGee's testimony. Dr. Alter didn't examine or speak to McGee. And Dr. Alter testified repeatedly that he's got no opinion about McGee specifically. Next slide. We asked him that same question here, and I won't read the entire question and answer into the record since it takes up this entire page of this slide, but I will point to the part we bolded in his answer, where Dr. Alter says, I'm not in a position as I sit here, based on the evidence that I reviewed, to make definitive claims about Ms. McGee. The question was, are you going to give an opinion? Right. If I ask you this question at trial, or if Mr. Neff does, do you have an opinion to a reasonable degree of scientific certainty whether or not Crystal McGee's use of the speed filter caused the accident with Mr. Maynard, or was a substantial factor in causing the injury or the accident of Mr. Maynard? Will you have an opinion on that or not? And the court might remember this morning we talked about substantial factors and the importance of that. And we asked him directly whether he was going to have an opinion on it. And he said, I'll have a broader opinion that I've just described. It increases the likelihood that somebody like Ms. McGee would engage in dangerous driving behavior like this. But unless some factor changes or Mr. Neff instructs me otherwise, I'm not in a position as I sit here, based on the evidence I reviewed, to make definitive claims about Ms. McGee. Specifically, I make broader claims about a class of individuals that includes Ms. McGee as an 18-year-old. He's not talking about McGee. He's talking broadly about 18-year-olds, about whom he has no data whatsoever about their driving habits or their use of Snapchat. Even if Dr. Alter did the work scientifically to study the speed filter users, which he hasn't, that would only result in a general in a general statement about the effect of the existence of the speed filter on users, but failed to address its effect, if any, on Crystal McGee. Dr. Alter's next opinion is about what Snap knew or should have known. This too is inadmissible because Dr. Alter is testifying on an ultimate issue without using any scientific, specialized, scientific, technical, or other specialized knowledge to help the jury understand the evidence or determine a fact and issue. Next slide. Ultimate issue testimony is, under 24-7-702, expert opinion testimony is only admissible where it utilizes scientific, technical, or other specialized knowledge to help the jury understand the evidence or determine a fact and issue. In the Carlock versus Kmart case, 227 Georgia Court of Appeals 356, the court said that a party may not bolster his case as to the ultimate issue with expert testimony when the jury could reach the same conclusion independently of the opinion of others. Here, Dr. Alter testifies about Snap's knowledge that the speed filter was dangerous based on a handful of emails and a single internal discussion. That is all that exists before the crash. Next slide, please. And as we mentioned this morning, this is not the first or only time that Dr. Alter has provided inadmissible and improper testimony about the knowledge of a party. This is the recent opinion in the social media adolescent addiction, personal injury products liability litigation, the People of California versus Meta Platforms, Inc. Dr. Alter was going to testify in that case that Meta was aware that consumers had major concerns about the effects of its platforms on the health and the safety of the users. He wanted to testify that Meta knew uncertainty or concern about platform safety could hamper the growth of its platforms and ultimately would hamper Meta's financial performance. Meta objected to this opinion on two grounds. One, that Alter was merely summarizing the defendant's documents and public statements to what Meta knew, which a fact finder could do on its own. And two, that Dr. Alter improperly spoke to Meta's state of mind when he opines on how Meta intended or sought to shape consumer perceptions. The court excluded Dr. Alter's opinion on this basis. We've attached a full copy of the court's order to our reply brief in support of the motion to exclude Dr. Alter's testimony. And so I won't read the entirety of it into the record. It's quite a few pages long. But this morning, the plaintiffs told you that that was the only, out of a laundry list of other objections to Dr. Alter's testimony, that was the only time that his testimony was excluded. And that's not exactly true. There's actually three different points here where the court excludes a portion of Dr. Alter's purported testimony. Elsewhere, on page 7 of the court's opinion, the court said that Alter's testimony concerning, he tried to testify that as to how consumers were interpreting Meta's message. He was saying, well, Meta's statements to the consumers were meaningful and important. And his report, the court found, made it clear that he was simply inferring that Meta's statements were meaningful because of his statement broadly that parents and youth are inherently concerned about youth well-being and safety. The court said, can't do that. You can't testify about what Meta intended when it's not based on any evidence in the record. Alter, similarly to what he's attempting to do in the California case, here, Dr. Alter is purporting to testify about what Snap knew, but he adds no specialized knowledge to his opinions about the documents that are in evidence in this case. Alter just reads them, and he testifies that based on his reading of this handful of emails, Snap should have known that the speed filter was dangerous. Now, the majority of these the documents that Alter relies upon that came from Snap in this case, the majority of these post-date the crash. And he can't rely on these documents to establish Snap's knowledge as of the date of the crash. Documents that post-date September of 2015 cannot possibly go to Snap's knowledge or what Snap should have known as of the date of the crash. As for the handful of documents that he relies upon that predates the crash, these are, next slide, please. So first, and these are documents that we've seen before. The first is an email from Micah Schaefer to Evan Spiegel in 2013. And this is a document that says, before the speed filter was released, one Snap employee sent another Snap employee an email saying, make sure we display a warning about not using while driving. And Snap did that. The second document that Alter relies upon is an internal discussion. After the speed filter was released, Snap employees discussed whether they should award trophies for posts using the speed filter. They decided not to do that because they didn't want to create a risk of harm. That's what that document says on its face. The third document is an email from a Norwegian journalist asking about the speed filter internally. Asking for the speed filter. Internally, after getting this email, Snap personnel asked each other, well, we put a warning on this, right? And the Snap communications employee asked someone at Snap who would know whether there was a warning on it or not. And that Snap employee responded, yes, we did. Next, there's an email from someone named Chris Cognac inquiring about the speed filter. This is an email from a retired police officer who said, this teenager I mentor mentioned the speed filter and thought that it might be used while driving. Snap responded to the email. We've pasted a copy of these emails into our reply brief. Now, Snap responded saying, well, we haven't heard of it being used for that. And also added that it's not as accurate or responsive as a speedometer. So it may be that those folks are more likely to show the car speedometer instead. In other words, on the face of this email, Snap is doubting whether people would misuse the speed filter. None of these documents on their face show that Snap thought the speed filter as designed with a warning would make people drive dangerously. Finally, Alter cites to a change.org petition that was posted online, even though there is no evidence whatsoever that anyone at Snap knew about this petition at any point prior to this litigation. Importantly, and just like the California federal court decided, Dr. Alter doesn't have any special knowledge with which to interpret these emails. The plaintiffs, in their response, they said, well, Alter, he's gonna tell the jury why an email from a retired police officer should mean more to Snap. But he didn't testify about that at his deposition at all. And when we asked Dr. Alter at his deposition what he knew about Mr. Cognac, here's what he said. Next slide. We asked, do you know who Chris Cognac is? All I understand is that he's a retired police officer, but I don't know about his relationship to Snap. Understood. Well, I mean, do you know anything about him more than what is on the face of the document? Answer, no. Alter offers no expertise, no specialized knowledge, and he cannot be permitted to testify about what Snap knew or should have known about the dangers of the speed filter prior to the crash. Next slide. Dr. Alter also seeks to testify that Snap benefited financially from the speed filter. Now, this is inadmissible for a number of reasons. First, it's speculative. Second, Alter offers no specialized expertise that would be helpful, that would make his opinion helpful to the jury in this case. Next slide. We asked Alter, so you say Snap stood to gain financially in opinion C. You have not quantified that meaning in reality, right? Again, whether that occurred or did not, right? Answer, no, I did not seek to quantify that benefit. Alter admittedly does not know whether Snap made money from the speed filter. Alter has no evidence the speed filter had any effect on Snap's engagement, on its revenue, or on its value. Dr. Alter has no information on whether or how much money Snap made from the speed filter, no information on whether Snap revenues went up or down based on speed filter use, and no information on whether Snap user engagement went up or down based on speed filter use. Next slide. We asked him, well, have you done any study of Snap as a business specifically, beyond looking at the documents that are in Appendix C? His answer was, there's no reason to feel that there's any difference between Snap and any other platform when it comes to deciding how to retain or build in features. It's for the same purpose because they operate in the same market space. Alter just assumes that Snap releases features to make money because he claims that every social media company does that. This is another unsupported assumption, and it's highly prejudicial. He cannot be allowed to testify and make such highly prejudicial statements when there's just no data or fact whatsoever supporting the premise of his idea or of his testimony. The plaintiffs asked this court and will ask the jury to assume that the speed filter caused Snap user engagement and accordingly the revenues to increase. The plaintiffs will claim the only evidence they need to prove that the speed filter caused user engagement and revenues to increase is the fact that the speed filter remained on the platform. This is circular logic, and it's unsupported. Having done none of this analysis, Dr. Alter's opinions do not help the jury understand the evidence. The plaintiffs are going to claim that Alter should be permitted to teach the jury that social media companies make money from user engagement. It's called the attention economy, they're going to say. This concept that social media companies make money from advertising revenue instead of selling a product is not an expert opinion, and it isn't relevant when there's no evidence in the record to support the premises that Snapchat made money off the speed filter. Next slide. Finally, Dr. Alter's testimony regarding the reasonable design of the speed filter is inadmissible. Now, he has no support for his opinion that Snapchat should have a Hippocratic oath. He conducted no risk utility analysis in this case. And perhaps most importantly, he didn't analyze the speed filter's warning at all. I will approach these each one by one. First, it's important to remember that Alter is going to testify to the jury that Snap's decision to introduce the speed filter is among a handful of the most egregious product decisions implemented by any social media company. But Dr. Alter is not a software designer. He's not educated or trained as a software designer. He's not an engineer. He has no professional experience designing or releasing social media applications. Now, the plaintiffs told this court in their response that Dr. Alter will not testify that Snap had a duty to implement a decision-making rule like the Hippocratic Oath. Good. Next slide, please. When we asked him if he could identify some industry standard that was applicable to social media or to Snap, this is what he said. He said, I'm not aware of a reified set of principles that stand in as an ethical charter. I believe in business there might be some general ideas about how you're supposed to do business that transcend the social media industry, but not specific to the social media industry. So there's no industry standard. He has no knowledge of any industry standard for the development of a social media application. Next slide. We asked him, well, do you know how many alleged incidents of bad misuse leading to injury were reported to Snap? And have you done any risk analysis? Like, despite the fact that I hear what you're saying, have you done any type of risk analysis extrapolation in terms of statistical significance of number of users versus horrible outcomes? Not asking you to judge it, I'm just saying, did you do it? He said, I didn't, and would not have found it a valid analysis for my purpose. He performed no risk analysis. So we've got no industry standard and no analysis of the risk utility benefit. Dr. Alter cannot testify about any industry standard to provide Snap's reasonable design duty and did not perform a risk utility analysis. He also cannot testify in any substantial way about Snap's design process. Next slide. I didn't see. Next one. Yeah. I didn't see in your report that you give an opinion about the sufficient. Okay. Sorry. Excuse me. Before I move on to the warning, I want to one more thing. Dr. Alter also testified that he does not know what the intended use of the product was. Alter simply concludes, without an industry standard, without any knowledge of the intended use of the product, and without having done a risk utility analysis, he concludes there's no benefit and the costs are huge, and therefore this is the most egregious product decision he's ever seen. That this opinion has no support only serves to highlight how prejudicial it would be for the jury to hear it from someone that they are told is an expert on the matter. Finally, Alter does not consider the warning on the speed filter at all when opining on the speed filter's design. And this is the quote that I wanted to bring to the court's attention. We asked him, I didn't see in your report that you give an opinion about the sufficiency of the warning, the size of it, the shape of it, the color of the pattern, where it appeared. Is it fair that you will not be giving an opinion related to the conspicuity of the warning or otherwise the sufficiency of the warning? He answered yes. As I said earlier, the only reason I bring up the warning is because it indicates that it was foreseeable to people at Snap before they introduced the feature that it would lead to this kind of behavior. Alter specifically testified he is not opining on the sufficiency of the speed filter warning. But his opinion on the design of the speed filter, without any of this information, his opinion that this is one of the most egregious designs he's ever seen is unsupported ipse dixit. And because Alter's opinions lack a factual foundation, and he relies on unsupported analytical leaps and invades the province of the jury, his opinions all rest on speculation rather than methodology. And for that reason, they should be excluded in their entirety. These opinions are so prejudicial to Snap, like the 11th Circuit in the Frazier versus United States, or excuse me, like in the United States versus Frazier case said, that juries assign talismanic significance to expert testimony. So the court has to take care to weigh the value of the evidence against its potential to mislead and confuse the jury. Here, Dr. Alter, he wants to testify about his theories and his ideas, but he doesn't have the methodology. He didn't do the work. He didn't do the testing. And because of that, that renders his opinions unreliable. And this court must exercise its role as gatekeeper to exclude his opinions in this case. Thank you.
All right, thank you, Mr. Bohr.
Can you, Mr. Masson, pull up that last slide, the warning slide?
What's that? This one?
Yeah, that's it.
All righty.
So I asked opposing counsel to put the warning slide back up. And the reason I did that is I want to use it as an illustration of the style of argument we're hearing about Mr. Alter. So they say, based on this, that Dr. Alter has no opinion on Snap's warning. And the question reveals what's happening here. They're asking him, do you have an opinion about the size of it, the shape of it, the color, the conspicuousness of it? His answer is no. So what that means is, I don't have an opinion, Dr. Alter, as to whether it should have been in Helvetica font versus Times New Roman, whether it should have been in size 10 font versus 20 font, and so on and so forth. That's not this case. We're not arguing that if you'd put the warning in giant bold letters, it would have made a difference. But the idea that he has no opinion about warnings is just simply false. So I've described what he's doing there. In Alter's expert report is on page 26, section 51. He says, quote, the tweaks and warnings that Snap introduced over time were insufficient to override the allure of these design features. And if you remember from this morning, which feels like an eternity ago, I told you that there were two things that he says about warnings. One was the inception. I'm gonna go back to my movie quotes. And the second was reactance. And I'm gonna quote from it this time. So first, the warnings planted the idea of driving while using the speed filter in users' minds, the first step in prompting them to consider the filter for this purpose. Second, the warnings are likely to have activated a state of psychological reactance in at least some of Snapchat's user base. And then he goes through and he cites journal articles about the way that teenagers react, their developmental state of mind. He is a psychologist, he's a marketing professor. These are all things within his expertise. And this is emblematic of the types of arguments you're hearing. You'll have these very narrow questions that ask a very specific point, and then they will extrapolate that to say that our expert has no opinion on warnings. That's obviously not true. He says exactly what I just quoted and have argued here. There's not a warnings case about the size. It's a warnings case about when you say, Snap, that you used a warning and therefore it's not foreseeable that someone would misuse it, the jury's entitled to rely on this opinion and say, no, in fact, these are the two principles. And these are not principles that a jury can simply decide on their own without expert testimony. An expert is entitled to assist them. The jury may choose not to rely on that expert, but this is certainly within the realm of a psychologist expert testimony. The second example that I want to use, and then I'll get to the specific opinions, it may have been earlier this morning, but there was an argument that Dr. Alter didn't consider Heather McCarty's statements. And so I want to again review the expert report. This is on page 15, section/paragraph 31. Quote, according to Heather McCarty, one of those passengers in the car with McGee, McCarty asked McGee to slow down when she realized the car was accelerating rapidly. McGee responded that she was just trying to get the car to 100 miles per hour to post it on Snapchat. I'm about to post it. Now, in opposing counsel's somewhat defense, my guess is that they're just looking at the list of materials that Dr. Alter reviewed, and I'm inferring that maybe they didn't see McCarty's affidavit. But again, if we remember the very long history of this case, because they were challenging whether we even had any basis to file this lawsuit, we just quoted Heather McCarty's affidavit in our complaint. So when you look at the footnote to 31, he's referring to the second amended complaint, because at that point we'd been accused of, generating a frivolous lawsuit. So we pointed to the affidavits that were in the record at the time and then were quoted in the complaint. So we just have a number of factual misstatements that we disagree with. I'm confident Your Honor will be able to review our expert report and the deposition and find those out. So I'm not going to answer every single one, but those were two that just stand out to me. So where I want to go next is I want to talk about the order from the social media case in LA, and then I'm going to go through Alter's 4 opinions and then just kind of explain what I think about each of them and why they're admissible. So if we look at the order from Judge Rogers in the, I think it's Judge Rogers. Yeah, Judge Rogers in the California District Court. Your Honor will read it, and it's fair to say we disagree about what it really means. I'll summarize it this way. There are 2 main limitations that Judge Rogers put on Dr. Alter's testimony. He is going to testify. He's not intending to testify. He is, given this ruling. But the 2 main ones are, Judge said, you can't testify as to Meta's actual knowledge. You can't say Meta actually knew X, Y, and Z because that either existed or didn't. And then the second thing that she said that Alter couldn't do is you can't testify that the users of Meta had in fact XYZ reaction. You can testify that it's likely, but not that they in fact had it. That's it. Those are the 2 limitations. I do admit it does apply sort of sprinkled out through some of his opinions, but those are the 2 main limitations. He has a number of opinions. Now let's talk about what she says is admissible. So on page 8 of the order, there is a quotation of some case law and then it's applied. So I'll read it. Courts have found that a marketing professional's review and analysis of company documents to extrapolate marketing strategies coupled with the expert's experience and background can be a reliable methodology capable of assisting a jury. Marketing experts are permitted to opine what a company intended to convey through their marketing. That's exactly contradictory to what they're telling you that Alter can't do. They're saying, well, they can't testify about what Snap intended. Under this ruling, it's correct that Alter wouldn't be able to testify as to Snap's actual knowledge, but what he can do is evaluate their internal documents, exactly what opposing counsel said he couldn't do, and make a determination based off of his marketing expertise and background and psychological principles as to what that's intended to do for a user base, in this case, the teenage users. It continues. Alter may explain how his expertise informs how a company may use certain kinds of messages to communicate particular messages. If we turn to page 9, Alter provides a basis for his conclusion that it's likely the statements had wide reach. So again, the distinction is Alter can't say under this order that all of Meta's users had this experience, but he can say that it was designed to have that experience or was intended based on their documents, and I should say, that this was likely to have the effect. Let me read one more from the order. Courts do admit expert marketing testimony based on the expert's own experience, review of the relevant literature, and review of the record. Doesn't say anything about scientific testing. The marketing experts and psychologists aren't required to do double-blind cohort testing. And then it continues this on page 6 again. Alter's opinions B, C, and G synthesize Meta's messaging messages to opine on what those communications were likely to convey to consumers. As such, they are admissible so long as they are couched in terms of what an expert would expect to occur, as opposed to a statement to what in fact did occur. So if we apply those principles to this case, what that means is precisely what I believe Dr. Alter has testified, is that he can say on a general population basis that someone in McGee's demographic is likely to have this kind of reaction to the speed filter. And then the jury, based on that expert testimony, so it's not a situation where we're saying that there's nothing going to the jury on expert testimony, can bridge the gap based off of their understanding of what they're going to have to decide whether Heather's telling the truth, or whether Crystal's telling the truth about what she said, about the fact that their friend group, Henry Williams, said everyone was using it, it was normal, about the fact that Kaylin Henderson was showing a Snapchat speed filter video before this wreck happened. And according to Henry Williams, Crystal saw that video. Those are all things that sort of take that general principle and apply it specifically. And while I'm on that subject, this is again yet another instance where opposing counsel will show a very specific quotation. You don't have definitive conclusions about McGee, and then say, well, he has no opinions at all. And over, Alter says exactly the opposite. So here's an example. I wouldn't say no opinions at all about McGee. Obviously, I have a sense of the extent to which McGee was driven to achieve a particular speed. I make broader claims about a class of individuals that includes Miss McGee. Over and over, he's including McGee in this. What he is saying, and what I said earlier, I hate to repeat myself, but just because it's the same motion or same issue, he's saying, I'm not isolating her as something, as some crazy addicted individual as opposed to someone else. And again, if they want to raise the arguments about that, that's for a jury to decide. And also note here, this was on the summary judgment briefing, but it applies here as well. I cited a case, Slotowski versus Sig Sauer. It's a that one's a Second Circuit case. So there's a bunch of lawsuits involving 6 hours. I don't know if you're a handgun person, but P320, inadvertent discharge. I looked at the security because police officers are a lot of the plaintiffs in this case, honestly, ICE agents, law enforcement in general. And there's a string of these cases where experts are allowed to testify about why the striker is essentially defective in there because it's so trigger prone. But courts have said, well, but you can't testify about how it exactly happened here, but that's okay. You'll have the testimony that this type of pistol is more prone to inadvertent discharge, and then the jury will hear about the specific circumstances of how it happened. So for example, in many of these cases, you've got someone says, I never touched anything more than the external holster, and it went off. And then the defendant says, no, actually, there's a video. It shows you can kind of see he's looking elsewhere. Juries decide those points. as long as they have the expert testimony that this was defective, had a general likelihood, the jury bridges those gaps. So those are my sort of general points on Alter. Let me talk about some of the specific opinions that were attacked. So first, does the speed filter encourage dangerous speeding? We've gone over most of this. I just reiterate, there is no legal requirement that you do some sort of specific testing. The cases that they're citing are largely toxic torque cases or cases in which there is a sort of, you've got to rule out other epidemiological causes. That doesn't apply here. And in fact, Judge Rogers' order specifically rejects that type of argument and saying that he can rely on his expertise as well as relying on the internal documents. The methodology is there. There is a methodology to understanding how teenagers react, how social media is used. Second opinion, Alter's opinion that Snapchat knew or should have known about the speed filter's danger. I will say if you apply Judge Rogers' order or adopt it in some sort of similar fashion, that would restrict Alter's ability to say Snapchat had actual knowledge, but should have known? No, that's exactly what Judge Rogers allows, and what we're saying should be allowed here is that Alter can testify based on industry expertise what they should have understood as opposed to what they actually knew. Third opinion is that Snap had financial incentives to maintain the speed filter. Now, I think there are two arguments that were made here. One is essentially that Alter can't quantify the amount of profit that was generated by the speed filter. And this is actually precisely why the jury needs to hear from Alter. There is no situation in which somebody can say this is the exact amount of money that you made. That's the whole thing about social media companies. They don't sell you a product. They sell your time and attention to advertisers, and it's all part of a bundled experience. They don't sell an individual speed filter. They don't sell the dog filter or the cat filter. I mean, that's just not how this works. Their entire goal is to take up as much attention, time for you, so that the moment, from anytime we have a break, we get on our phones. We don't pay for that individually. It's all paid through the ability to say to advertisers, this is how much money we generate. And the jury needs to know that, because otherwise they're going to say, well, they're going to ask, why did you still have the speed filter? And the jury needs to understand that it's all bundled together. That's how they make this money. We all know that the fact that this attention economy exists, I agree with that, but why and how it operates, that's not something an ordinary juror knows. And where expert testimony is useful. And again, the opinion from Judge Rogers largely allows that same testimony in this case. And the reason that it's relevant is it goes into, number one, the risk utility analysis, and also is relevant to our conscious disregard, that the reason that they continued to maintain the speed filter, even after they received notice of these dangers, is that this is how they make money. They make money off of the ability to, again, dominate our attention and time. There's no legal requirement that you put it in specific financial terms when that is not remotely possible. And the prejudice argument, I'm not entirely sure how that works. I think it's more an explanation of if he fails Daubert, then yeah, I suppose, yes, at that point it could be prejudicial. But that there's not some sort of separate Rule 403 analysis going on here, nor is there some argument that, okay, well, yeah, the evidence is bad for you. That is prejudicial, but that doesn't make it unfairly prejudicial, nor does that make his opinions not useful. Finally, the Alter gives no opinion about design defect. I think I've largely covered this before as well. There's no requirement that he conduct a specific kind of test. In order to do that, there's no formal risk utility analysis that he is required to do. This is simply a question of, is there a utility to this product and what are the risks? And the idea that he is not a coder, it just doesn't make any sense. It's not a coding issue. I agree if the question was, did the speed filter use too much data on your phone, or was it written poorly? If our negligence claim was that the app crashed, maybe that would make sense, but that's not what this is about. The reason we have Alter testifying as a psychologist expert and a marketing expert, and the reason why he's testifying and was hired by the state of California, hired by the state of Florida, is because it's not about the code. This is not that's not the science here. The science is how do people react to this type of incentive. And Alter not only comes to that from a perspective of social media, but also from the specific user base of teenagers. And the idea that he doesn't, that all social media companies have this same sort of model, I don't know how that makes his data unreliable. In fact, it makes it more reliable because that is true. I mean, there's no evidence or anything else that suggests otherwise. But ultimately, at the end of the day, with all of these issues, whether, again, they want to argue that social media has not had the impact that we all think it has and that teenagers have been driving recklessly forever, they can make that argument to the jury. There's nothing unreliable about the jury. And I guess I'll close with the Frazier quotation. So Frazier is the case that was cited from the 11th Circuit that Mr. Bohr cited. That case also emphasizes that rejection of expert testimony is the exception, not the norm. And Your Honor knows this, the traditional tools of cross-examination, closing argument, that's how we address those issues. Any questions?
Okay, so, and then this will come back to Mr. Bohr for his round on this, but just to finish it up. So Alter, as you all are aware, I'm catching up as quick as I can.
Yeah.
Alter, I see three main topic points for all of these that are coming. So I'm just giving you the pattern of my questions as you wrap up each of these. I see their testimony as to just the general social or aggregated impact question. And then I see specifically to McGee, and then I see specifically to SNAP. If I'm seeing that correctly, I'm hearing for y'all's presentation of Alter's testimony, his main thrust, as it would be the aggregate level testimony. Tell me if I'm missing that or if I'm kind of getting the gist of the issue here.
You're getting the gist of it
Okay.
mostly. And I think the only qualification that I would put on that is that's sort of the lead. That's the main analysis. But he then does tie it to McGee. And he's not making, again, I agree. He says he's not making a definitive characterization, but he does look at certain specific facts that do tie it to McGee. But I agree. The gist of it is this is people like McGee, people including McGee, are likely to have this reaction.
All right. And then finish that, do that same explanation with SNAP. Is he wanting, what exactly is he? Help me understand
same.
what his testimony is going to be as impact to SNAP directly or just the generalized aggregate?
Yeah, so it's very similar. So you have the generalized aggregate attention economy. The way that social media companies make money is the more user engagement they can show, the more value it has to advertisers. And then it's tied to Snap specifically. So among other things, he talks about how Snap's business model is arranged. Like, for example, they don't sell individual products. They had like the glasses for a little while. So that is sort of on the business level. And then on the specific level of the speed filter, one of the things that he talks about is how the speed filter turns an otherwise utilitarian act of getting from one place to another, an asocial act like you're driving by yourself, into a social gained situation. So it takes that rare moment. It's like, I hate to use this example, but when we're sitting on the toilet and we're looking at our phone, that's the type of attention that they're trying to get. And so he does that on a general level and then does it specifically for Snap as well.
All right. And then let me add one last kind of topic here, which is that, is he going to want to provide, is he don't want to provide any sort of testimony as to this crash specifically on this issue? Or is that part of what his testimony is about? Like causation or anything like that?
So I guess it really depends on what you mean by this crash specifically. So is he going to be talking about, well, if she'd been going 80 miles per hour, this crash wouldn't have happened? No. But is he going to say, for example, Heather McCarty had said in her affidavit that she was McGee was trying to hit 100 miles per hour. He will talk about not that fact happened or not. He's not going to be saying, oh no, I'm deciding whether that happened or not. Assuming that testimony is true, assuming Heather McCarty is correct, then here's why that is likely to have happened, why Crystal had that effect. And that gets into the reactance theory, the inception idea, the desire for humans to want to give objective numerical values. But he's not going to be testifying, no, Heather's more likely right than Crystal. I agree, that's not happening. And all this, and he admits it, that's not what he's here to do. He's here to provide the jury with a way of understanding how these things happen, assuming they agree with our witnesses versus their witnesses, basically.
Okay, perfect. Thank you.
Yeah.
Again, I was just trying to bring it a little bit more concrete from the framework I've got to apply to all the witnesses so that I can
Oh,
see
no,
a pattern a little easier from my perspective.
I'm, as you know me as an appellate lawyer, I'll take questions anytime I can get them.
No, that's all right. And of course, it's always interesting to me that this is not the first time you've appeared in front of me on that specific stretch of road. I just think that's very interesting. So
I was telling somebody about that as well.
I've had 3 cases off that stretch of road. Anyways, I don't know. It is what it's not in Spalding County. It's not mine, but it's the stretch of road that's kept me the busiest over the last 10 years. So anyway, I would love, Mr. Board, to give you a chance to kind of follow up on that. You caught, I was looking for 4 pieces. You're welcome to move. The aggregate level, the McGee level, the SNAP level, and then specific accident on this case. And obviously, Ms. Gower, if you want to speak into it, you're welcome to.
Thank you, Judge. Your Honor, with respect to the plaintiff's portrayal of Dr. Alter's testimony, I think this is one where it's important that the court just read the deposition. It'll speak for itself. I showed the court when we asked Dr. Alter specifically if he was going to have an opinion about the warning, and he said no. And now plaintiff's counsel points out, well, look in his report here. You didn't ask him the right question. You didn't say the magic words. And if you would have said the words the right way, he would have given some kind of an opinion on a warning. But we asked him straight up, do you have an opinion on the sufficiency of the warning? And he said no. I mean, that's in the transcript on page 72. So I would just ask the court, it's useful to read the whole deposition for Dr. Alter. He's not giving an opinion on the warning. And plaintiff's counsel brought up likely reactants. So basically they're saying, well, you made a warning, and that's where you went wrong and made her do it. Well, if that's not a theory, I don't know what is. I mean, he's just saying it. There's not a shred of data. There's not a shred of evidence to support that. It's simply an idea that's been untested and unanalyzed. There's no science about how anyone reacted to the speed filter warning. There's no data, there's no analysis, there's no testing. And you can't just say something without some kind of data to support what your opinions are. Now, we asked about, Judge, you asked about the aggregate. And it seems like that's the extent of Dr. Alter's opinions, right? I mean, according to him, all teenagers are the same, and all Snap and social media users are the same. All social media companies are the same, right? So there's no need for this court to differentiate between any teenagers. There's no need for this court to differentiate between any social media companies. Now, that's simply not reliable opinion testimony. Alter wants to testify that the speed filter increased the chances that something happened without any data, without any analysis. This is not an opinion where he read like what I imagine happened in the Meta case, where he read a bunch of Meta's marketing materials and then interpreted them, giving plaintiffs the benefit of the doubt, right? And I imagine, I'm sure that Your Honor will read that order in its totality. But giving the plaintiffs the benefit of the doubt there, one can imagine that Dr. Alter read the marketing materials before he opined on them. He's not doing that here. He is opining on the chances that the speed filter increased the chance that somebody would drive dangerously without having any data about it at all, just because he thinks that's what would happen. And that's just not proper expert opinion. He wants to testify about he doesn't want to testify specifically about McGee, but he wants to wrap McGee up into that teenage category. Well, all teenagers are running risks, and all teenagers are more likely to drive dangerously because the speed filter exists. He didn't even know if McGee had used the speed filter before the date of the subject crash. It wasn't necessary to his opinion. He can't have an opinion on McGee and whether this speed filter increased the chances that she would drive dangerously on September 10th, 2015, when he never talked to her before, never read her deposition, doesn't know anything about her. It's simply unreliable and unsupported. Now, it's with respect to his opinions about social media companies in general. I mean, he is not utilizing any industry level expertise when he's talking about social media companies. They just want to make money, and here's how they do it. There is no expert level specialized technological knowledge to support that opinion. Once again, this is simply ipse dixit. And it's something that this court must exercise its role as the gatekeeper in order to prohibit Dr. Alter from providing these unreliable opinions to the jury in this case. Thank you.
All right, thank you. Any additional response, Mr.
No,
Chandrika? All right. All right, perfect. We've been at this right another very quick break. Everybody stretch your legs. And what's the next topic up?
Bowie.
Okay. And we'll tackle Bowie as soon as everybody stretches their legs and gets back in their seats. It's really hot in here. I'm just going to say out loud, I know I'm going to take us off record. screen. So
Yeah, as always happens, it wanted me to restart my computer, which I'll never get the PowerPoint back if I do that.
yeah, nope, that's exactly right. You ready for me to push that up?
It should be back to what's relevant here. I'm not sure
Let's see if that works. Is that it?
it is. Okay, hold on a second. Let me
What answers the question?
just ignore all that.
We'll come back to that. In
Yes, I didn't make this stuff. Okay.
Oh,
you demonstrate.
yeah. You almost. Good God.
I need to put that in.
Okay.
That's 13.
5%
Yes. That's holy shit.
There we go.
Oh, there we go. All right.
That'll work.
What answers the question of whether she
This is what I want to start with, but I don't know how to get, it won't go forward. I want to go forward.
Let me try with the arrow.
Hold it.
we'll come back to that.
I'm just gonna get out of this for a second. Yeah. Okay. It's going so well.
There's always a moment. And I can pull it down.
No, yeah, I'm just gonna run. I'm gonna get down there. It just went back all the way to the beginning, but this is faster. Okay, don't talk. Okay.
All right. You ready, Kathy? All right, let's go back on record. Before we jump into the next matter, which is Dr. Bowie, I just want to point out, make sure the record's clear that something's wrong with the air conditioner in this space. It is very hot. So I've told everybody they can take their jackets off or whatever just to survive. So anyway, I'm just saying that out loud.
Thank you, Judge.
All right, floor is yours.
May it please the court, if it's okay, I think I may disrobe as I argue a little at a time, just to keep us interested this afternoon. Okay, so we're moving forward to Dr. Bowie, and you've heard about a marketing professor with a psychology degree who didn't examine or even take the time to read the testimony of the person who allegedly misused illegally the app and hurt their client. We're now moving to Dr. Bowie, but what I wanted to do from a framing standpoint, Judge, is I wanted to give a title to what the questions the court asked, right? It seemed that the court was asking what is predominant through whether it's Daubert or Fry or other 702 standards throughout the country and specifically in Georgia. One of the questions is, does it fit the evidence, right? Does the opinion fit the evidence? So we've got all these criteria that all the lawyers have been talking about so far. But then the last part under that, after you get to qualifications, reliability, is it based on sound science? Did they demonstrate that they applied scientifically their opinions or their experience to the facts? The last thing is, does it fit? How does it fit this case? And if it doesn't fit the case, or if it's an overbroad opinion, as we heard related to Dr. Alter, without any specificity to the question before this jury, then it should be excluded. And the reason for that is because it's prejudicial, especially when it comes out of the mouth of somebody who's an expert. For Dr. Bowie, first on qualifications, I want to point out, and we did this in our brief, but Dr. Bowie has never been asked to give opinions like this he testified to, and he's never been qualified by any court anywhere to give opinions like the ones he seeks to give here. He is a computer science professor. He has never worked in the modern era. His last experience where he might have been called a software engineer was in 1985 or 1986, more than a decade before he even owned a cell phone himself. More than 2 decades before the advent of smartphones, and a little more than that for apps for smartphones. He simply does not qualify as an expert to give an opinions about any kind of decisions made at a software company in the modern era. Equivalent analogy perhaps crude, but equivalent, is at the advent of the automobile, there were most likely transportation professors who talked about modes of transportations. And they undoubtedly could talk at length about the horse and the buggy and other non-motorized cars. But to allow them to come in with no experience whatsoever working at a car company to talk about the design of a Tesla would be inappropriate, right? They're far, far, far removed from any relevant experience, any relevant, his training and education that he described was in part before computers existed, let alone smartphones. And so you roll out education, you roll out experience, and you're left with him being a computer science professor who sometimes teaches software engineers to be, and sometimes gives 2 lectures a semester about ethics. And so from a qualification standpoint, which I have gone through in detail in the brief that we filed, and cited to the areas that describe why he is not qualified. I don't think the court needs me to repeat, nor will I repeat every single one of those. But again, as there seems to be some type of common thread of suggestion, right, that we're playing sleight of hand. I think we got in this brief, we got sleight of hand, black box, magician's trick. And what I would submit to the court is that this isn't sorcery, right? And these are not perfunctory motions that we're filing because we just want to take up the court's time and kill trees. These are well supported after deposing these experts, motions that we believe ought to be granted. Now, let me tell you about fit as it relates to this metadata. I mean, there's subparts to it, Your Honor, but Dr. Bowie, in essence, is given his opinion or purports to about the reliability of the Blizzard data, right? And then secondarily, he gives some opinions about technical capability to track speed and I guess stop speed filters from driving at speeds. He gives this ethics opinion that he believes relates to their decision making. And he gives an opinion about the app's capability being inconsistent with the evidence in the case, but he didn't even read all of the SNAP deposition testimony. I don't really even understand that one. And then lastly, he purportedly wants to say that the best source of truth about the app's capability would be the source code, which SNAP says does not exist. That's from his disclosure that he wrote. In his deposition, again, as an example, you know, he's never actually looked at in his life source code for a social media app, right? But then, so how in the world does he have qualification or foundation to talk about source code for social media being the source, the truth or the source of truth about the app's capabilities? Also, as I mentioned earlier, on that opinion, that the source code did not exist at the time of his review is because the source code was never requested, nor was he ever retained as an expert. The other thing I would say about source code, to try to get rid of these 2 last categories, is that he testified that there is a program where you can go, I forget what it's called. It's like RSK mirroring. And you can apparently go on and get older versions of applications with their operating system. And so what Dr. Bowie testified when I deposed him in Chicago was that for 2 years, roughly, after a version or whatever of an operating system or an app changes, you can go on and you can pull that RK, what's it called? AKP, that's it. AKP imaging. You can put it on an exemplar phone and you can see how the operating system or the app interacts with the phone. He testified he knows how to do that. He could have done it, and he was available as an expert to do that. In the 2016-17 time period, he was not hired to do so. To allow him to now make the basis of his opinion that he doesn't have the source code would be contrary to Georgia law and discovery rules, especially when it was never asked for until very recently in the saga of this case. I'll show you the specific testimony, but just to handle opinion 6 at the back of this report, he gives an opinion that SNAP failed to implement feasible warnings or UI safeguards. And similar to Dr. Alter, when pushed on cross-examination, if he was a warnings expert, or if he had ever had any experience in putting warnings on software applications that go on smartphones, he has no experience, and he admitted that he's not a warnings expert. Okay, so coming back to the other 2 opinions. The first one relates to the blizzard data. And so as it relates to fit, right, that the plaintiffs seem to suggest that we're selectively saying what is relevant, right, about the metadata. And they said something about you lie to somebody 60 times or something, 60 million times. How do you believe him on the last time? Well, when you look at Dr. Bowie's testimony closely, what Dr. Bowie's opinion actually is he doesn't think that it's reliable because there's missing sequence IDs, there's gaps in sequence IDs, and there are duplicates of sequence IDs. And I said, well, Dr. Bowie, do you know, right, whether that's by design or accidental? He didn't know. Do you understand that what the sequence IDs being duplicate means? He says yes, and he quotes to some testimony from SNAP. Does that have any significance to the reliability of the data? No. All right, well, is the sole basis for your opinion that the metadata is not reliable that you intend to give to the jury these missing and gaps in sequence IDs? And he says, yes, that's the basis. And I said, well, have you done anything to figure out whether or not, have you done any testing or anything to determine whether or not there's any significance to that? No, I can't. Oh, so what does that mean? Well, it's just a theory at this point. Okay, well, what's the theory? The theory is, well, the phone might have been damaged in the car crash, and that would have led to the data not relaying about usage back to the SNAP server. Of course, she didn't read Ms. McGee's testimony where I asked her, was there any damage done to your phone? No, it worked just fine. No damage to it in the crash, none. So when confronted with the fact it's a theory, I said, Dr. Bowie, I understand you got this theory. You mean it's a possibility, not that you have an opinion to a reasonable degree of scientific certainty, a probability. He says, I can't test it because I don't have the source data. So he admits that he has no basis other than a theory to begin with about what these missing sequence IDs mean, whether there's one sequence missing ID or there's 60 million or 6 million missing sequence IDs. And so to avoid talking about metadata that over time changed in the way it was stored, and talking about metadata that stores in the bulk storage many things that have nothing to do with user data, and the SNAP witnesses have explained, I would say ad nauseum, I said, let's focus on testing your theory related to the night or the 12 hours around the accident. But before I did that, I asked him, I said, what data answers the question about app use the night of the accident? This isn't us hypothesizing or narrowing it. I asked their expert witness.
What answers the question of whether she was, I'll strike the question. What data answers the question of whether or not Ms. McGee was using the app or misusing the app while she was driving her car?
So are you asking me, what kind of electronic records would lead to concluding one way or the other that she was using the app or not?
No, I mean, what period of time of data do you need to look at?
Oh, what period of time, data? Relatively small window, maybe, 1 hour before and a few hours after, the crash occurred.
Next slide. Finish. Next slide.
What answers the question of whether she
Next slide.
asked? We'll come back to that. The blizzard data that you
Just go to the
reviewed
next slide.
on the day.
Okay. And then I asked him, using I expand what he says of an hour before and 2 hours after to 12 hours. And I asked him whether or not his theory or basis questioning the reliability applies to the data that answers the question as to whether Miss McGee was using the app while driving.
Did you demonstrate?
No.
Can you demonstrate now
Here,
or provide it?
Oh, I see what you're saying. It's just, yeah. Okay. So of course, I myself or the point in this the back of this side. So then argument. What happened?
No, I pulled it down while y'all were figuring it out.
Thank you. All right, I think I'm ready.
All right, I pushed it back up.
What answers the question? We'll come back to that. The blizzard data that you reviewed on the date of the accident, which is September 10, 2015, right?
Right.
You looked at that particular date?
I did.
All right. And on the face of that, meaning what that metadata shows, it shows that she did not use the phone in the period of time that she was driving that automobile that night.
Objective form, you may answer.
Yeah, the metadata does not show that.
All right, excellent.
We'll come back to that.
All right, now put it up.
In the ballpark 12 hours from around 3 p.m. to 3 a.m. the next day on September 11th, is your read of this metadata that there are no missing sequence IDs contained within the blizzard data for Crystal McGee during that time period?
Yes, I agree.
And if we look at more specifically the time period where she is alleged to have been driving the car, there does not appear also to be any missing sequence IDs, correct?
That is correct.
There are also no duplicates represented in this roughly 12-hour
That
period,
is correct.
and there are no gaps in sequence
There are,
represented in this 12-hour period.
yeah, if you sort, the rows, by sequence numbers, but there are no gaps.
Let me ask that question again. There are no gaps in sequence in this 12-hour period in the
Yes.
blizzard data.
Yes.
I'm correct?
Yeah, you're correct.
All right, and so the point of this is I asked him what formed the basis of his theory, untested as it might have been, that something was wrong with this data. And then I apply it with him, as you just heard, Your Honor, to the facts, right, of the, as he was presented, to the data he was presented. And he admits that if you apply his methodology, right, and you look for missing sequence IDs, gaps, duplicates, or anything that would indicate that there is something missing about user data, or meaning what the app was used for, applying his methodology, it doesn't exist. And so
In the ballpark,
and then I asked him just to make sure whether he had any opinions that disagreed with what the SNAP engineers had said. And I asked him, did he have a reasonable degree of certainty, scientific certainty, probability that the blizzard data is unreliable? And this is what we got.
did you demonstrate, or can you demonstrate now, or provide any evidence specifically that shows that something occurred on the phone related to the Snapchat app, speed filter or not, that is not reflected in the metadata in the 2 hours surrounding the automobile accident with Mr. Maynard.
So you're asking me if, I believe that could have been events that occurred on the mobile device that are not reflected.
I'm not asking you could it, I'm saying demonstrate to me evidence or proof that supports the basis of your opinion that something happened that is not reflected in the metadata.
Okay, so I'm unable to demonstrate that, because in order to demonstrate that, I would need access to the source code or the server data or both, and that has not been supplied to me. So I can only explore possibilities for how that could have happened without corroborating them, without evidence.
So to Dr. Bowie's credit, he honestly answers that he cannot answer that question to a scientific degree of probability. And for that reason, related to his opinions, they should not be allowed to be given to the jury. Speculating or giving theories or educated guesses about why data might be incomplete or what something might mean when you admit that you're unable to conclude that scientifically is exactly what 702 is designed to present. Now, moving to another topic. The only advertised opinion has to do with software engineer and designer ethics. And he provides some IEEE, that's electrical engineering codes. Two of them, one of them's from the late 80s, one of them was enacted in 1990. And he says, well, these codes mean you have to do risk benefit analysis. You have to do testing. You have to do usability studies. When looking or analyzing his ability to give that opinion related to these ethics standards, we don't challenge that in some of his classes, some of the time, he may reference these standards. What Dr. Bowie cannot do, and he admits he cannot do, is he has no experience drafting any kind of regulations, testing, usability studies, risk benefit analysis, anything that somebody like a company like Snap or any kind of software application designer for a mobile smartphone, he has no experience whatsoever working with industry or knowing what is used. He can't identify a standard of care. He hasn't participated in any way that would give him a look into see how actual companies in the industry go about developing their apps, deciding what testing is and isn't appropriate, making decisions, etc. He hasn't done that for 40 years. He's not, as I said, seen the source code for a social media app. He's never drafted, designed, implemented warnings. He's never advised a company on warnings, and he admits at page 199 and 285 and 286 that he is not a warnings expert. He's never produced a commercially available app. He's never involved in any software application that went on another person's phone. He's never worked at a social media company. He's never worked at a software engineering as a software engineer. He's never consulted with software engineer design companies or social media companies. As it relates to his testimony about data, I think it's important to note on this qualification that I asked him, I said, well, are you a data engineer? No. Are you some type of data scientist? No. Have you ever done any work in your life, right, that you would compare to the compilation of millions of users' data into a cold storage and into the Blizzard software, right? And his answer was, I helped write a program that collected pictures of zebras from the internet. Right? That's as close as he could get to any type of compilation of data in something that would be, I guess the plaintiffs would argue, equivalent to Blizzard data. He frankly is not, by admission, qualified to be giving opinions about the Blizzard data, but certainly not a standard of care for an industry in which he's never worked. As I said earlier, he's never even seen the app work.
He's never opened Snapchat on an exemplar phone, on his phone, on Mr. Neff's phone, on Mr. Adams' phone, just never even seen it. And he testifies to that at page 10 and 11. He's never been responsible for pulling data like Blizzard data. He criticizes sort of, as I just went through the Blizzard data, but he can't point to any commercially available better option. He can't testify that there's some, product that would have been state of the art that would have been a better forensic tool or would have provided information. He's not done any drafting or training for industry or software engineers or app designers for these ethics codes. He admits these ethics codes on their face don't say anything about software apps for smartphones or social media. He's never given that training to any company or any software engineers in the field. He's never designed any product safety testing or protocols for any company. He's never participated in the design of a smartphone application. He's never participated, watched, seen, or designed market testing or usability testing in the industry. I've already showed Your Honor the clip where he testifies that he didn't do a risk-benefit analysis himself, applying to the speed filter or the Snapchat app in general. He's never done that for any other smartphone application either. He's not done a usability test related to the speed filter or the speed filter or the Snapchat app in general. He's not, the plaintiffs purport to have him say, well, I think these ethics guidelines say that these studies should be done. But again, he did nothing, and he admits it, to determine by doing any kind of replication of that study or even approximation of that study so that he can opine that a different or more reasonable decision would have been reached if that study had been performed. It lacks scientific reliability for that reason. He's never been approached or previously testified in any case about decisions made by software engineers or developers or anything related to their ethics. This is the first and only time. What he reviewed to reach his opinions by way of evidentiary foundation is attached, I believe, as Exhibit 10 to his deposition. I believe this is an exhibit, at least to our reply brief or one of the two briefs. But one of the things I wanted to point out as it relates to the metadata, to how the app collects and interacts with the phone, whether or not Ms. McGee was on the app the night of. One of the things I wanted to focus the court's attention on is that he reviewed the affidavits, 2 for Mr. Fong Lee, 1 for Timothy Sane, 1 for Blair Mason, and 1 for Jack Brody. And these are not throwaway witnesses, right? These are folks that were leading groups of data engineers or software designers. They had specific knowledge related to the Blizzard data, how it was kept, how it was gathered. A lot was made about, well, it's a black box, right? How the Blizzard data works. Well, no, it's not. There's these folks gave affidavits. They flew out to California and met with them and got to ask them questions, as far as I know, from Mr. Trigg's affidavit without any limitations. Now, it wasn't under oath, but they weren't limited in any way. They could easily have then requested or taken the depositions if they wanted to pierce the things that were contained in those affidavits, or explaining reasonably how they reached decisions and how they kept data and why the metadata was reliable, and they didn't. And so I was curious, right, in the absence of the lawyers doing that in the form of deposition, whether or not Dr. Bowie had reached any opinion to a reasonable degree of scientific certainty that what they were saying was inconsistent with what he would deliver at trial, and he could not do it. He said he didn't hold that opinion related to the affiants that I just mentioned. Their affidavits should be of record, but I would encourage the court in looking at what that means as it relates to the opinions that Dr. Bowie, at least plaintiff, intends to give or have Dr. Bowie give, look at his agreement and his lack of challenge to what those witnesses say in terms of the foundation. He essentially agrees with Snap's theory of the case. The spreadsheet, I'll talk about this a moment in Mr. Persinger's argument, and so I don't want to like go through it twice. As it relates to Dr. Bowie, the only thing to remember is that Dr. Bowie says unequivocally that he has no criticism, and he is not accusing, nor does he see any evidence that Snapchat or its lawyers or whoever touched it manipulated these Blizzard spreadsheets. It might be a theory. It might be something that keeps being thrown up against the wall in this courtroom, but their expert says he sees no evidence and he's not going to testify or give an opinion that that occurred. So in terms of what we want, right? We don't want generalized opinions from an expert about our Blizzard data when he admits that he hasn't tested them or whatever it is he thinks he would need, he hasn't seen. We don't want Dr. Bowie to give opinions about the industry or decisions of industry that he admits that he is not have experience, real world experience, or even consulting or observing experience. This is not an insult of academia. However, the person who is going to opine that the actions of a company or people at a company was unreasonable, was negligent, did not consider, did not follow the standard of care, was inconsistent that what other app development or designers did. They have to have some experience, some relevant experience, or their opinions don't fit this case. Can he talk generally about computer science? Yes. Can he identify these ethics codes? Sure. But he has to then have an opinion that goes with a reasonable software designer, engineer, data scientist, or a company that employs those people. He has to have the experience in order to know what that standard is in the industry, know what reasonable companies did, or have some view of it, and then be able to testify whether he believes that what they did was reasonable or not. Notably, they don't say he's going to do that in his report other than the things I mentioned. Okay. So he shouldn't be allowed to give an opinions that he's not qualified to do. He shouldn't be allowed to give an opinion that he admits he can't support scientifically. He shouldn't be able to give warnings opinions veiled as something other than warning opinions when he says clearly he's not a warnings expert. He says it 2 times and he explains. He doesn't say, I guess to the extent that there is any other warning, he said they purport that he will give information about modifications that could have been made to the Snapchat app. He has no support for that beyond that they were later made, right? And the jury doesn't need an expert to tell them something that the witnesses can say as a matter of fact. And so I think our briefs are pretty detailed. I think that we made a very concerted effort to provide citations from his testimony to every assertion I made here or forgot to make here that's contained in our brief. As Mr. Bohr suggested, I think it is worth reading it in totality, one, to see how it fits, and then to examine his qualifications, the methodology employed, and whether he admits that he was unable to reach a scientific conclusion. But for all of those reasons, we would say that Dr. Bowie's opinion should be excluded. And if they're not excluded, they should be limited to the areas. They should be limited severely. Thank you, Your Honor. I'll sit down unless you have any questions.
All right, thank you. I'm going to save my questions for you until the next round.
Okay, sounds good.
Floor is yours.
Screen?
Yep. Okay.
As I think about the foundational argument that Snap has been making since the inception of this case. And they're using it in a bizarre fashion against bullying and about to use it on cursing words according to that. In fact, let me pause and say this, when law school students read this transcript 50 years from now, I want them to know that Baylor Taylor is celebrating his 70th birthday today. It might be 50 something, but they're gonna know. Just as you know, congratulations, sir. So look, Judge, SNAP is asking us to accept these spreadsheets as gospel and underlying that, and they're using that. These are true, and therefore the testimony of these experts is not admissible, should not be accepted. And I will set the table first before we get specifically into the ruling. And I'll have fun with it if the court will permit me. Let's say that I've been accused of spending a lot of time with big voting, and someone's taking me to court over that. And I decide, you know what, hey, I'm gonna download my bank account statements, and they're gonna come out in an Excel file, a CSV file, I'll put it in Excel, and presently I will give it to the other side. And the other side gets these Excel documents and looks at them and, wow, you know what, it doesn't say big voting anywhere here. But I see where, wow, you donated to the Hungry Children and Mothers Fund at 2 a.m. on Saturday night. And I see this and I see that. Well, if you ask the expert, do you see anything in this document that says that Dwayne visited the pink pony? All the expert can do is say no. I don't see it. But that doesn't mean it's not so, and it doesn't mean that I don't have questions about this document. And that's what SNAP is doing with these Excel spreadsheets. Let's talk about Daubert. We all know what Daubert is, and I agree with Mr. Masterson that you just don't spend time going through the Daubert standard and oral argument. But I think we should talk a little bit about what Daubert is not intended to do. And it is not intended to serve as an excuse for an automatic challenge to the testimony of every expert. We identified 8 experts in this case at SNAP, deposed 7 of them, and they're challenging 6 of them. That sounds like an automatic excuse to every expert. That sounds like, you know what, I'll file it. The worst that can happen is I lose it. And that's what we're dealing with here, because each one is unqualified or is extending their testimony beyond their qualifications according to SNAP. But as Naveen mentioned it as he was dropping the mic and heading out, the proper remedy if a party disagrees with expert testimony is vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof. And that's what SNAP has given to you today. They've given what they should be giving to a jury to say why you should not believe this expert or why you should believe someone else above the expert. And so for that reason, courts do not resolve conflicting expert testimony because that's the province of the jury. And I'm citing Fireman's Fund, the Holder Construction. I believe we cited that on our brief. This was more law, but I thought this was important enough to put it in its own section, and that is weight and not admissibility. The challenges that you're hearing from SNAP go to the weight of the expert's testimony and not whether the expert should be allowed to testify. Even if the expert's opinion is based on inadequate knowledge, this does not mandate exclusion of the opinion, but rather presents a jury question as to weight. If it be developed that the opinion is based on inadequate knowledge, this goes to credibility of the witness. They say there's nothing new under the sun. And I sometimes think that is true because defendants have been using this style of argument as long as Daubert has been on the books. In this case, this is J.B. Hunt Transportation Incorporated v. Brown, 236 Georgia App 634. This was disapproved on a completely unrelated grounds. So as far as I know, it's still good law. And then this was a trucking case, and in that case, the defendants wanted to exclude the expert's testimony, and they had reasons. He testified it was possible for the accident to have happened a different way. He could not testify with scientific certainty that it happened the way he opined. He didn't go to the scene. He didn't inspect the wrecked vehicles. He didn't interview the drivers. He didn't know how long or how fast the parties had been driving prior to impact. He didn't take it, and on. And the court said, all these factors go to the weight. and not to the admissibility of opinion. In other words, as we cited a moment ago, cross-examination, presentation of contrary evidence, that's what the defense does before the jury if they have problems with the basis of the expert's testimony. And finally, the appropriate standard is not whether it is conjectural or speculative to some degree, but whether it is wholly so. So the defense acknowledged, and I won't belabor the fact that Professor Bowie has years of teaching experience and so forth. We know that. More on point though, he has designed his own apps. He teaches app design as part of his classes. He walks his students through creation of live apps. He teaches design ethics as part of his courses and has done so for the last 20 years. He has co-authored 14 articles and written 52 conference papers. And Snap portrays him as a dinosaur. The last time he did this was this many years ago before he had a phone and so forth. Well, he has testified in 36 cases, including at least one case where he was hired by the defense firm who has just been questioning his qualifications to testify in this case. In the overwhelming majority of these cases, he has examined source code. But here's what you heard, and my ears perk up every time they start saying he has never, and they start getting really, really particular. Well, he has never examined source code for a social media app. And that's how they try and get you. They get so specific that, well, gee, maybe it doesn't apply to anybody. He offers 6 opinions here, just 6. They're attached to our brief, and I'll probably Snap attached them to theirs as well. But I'll go through them briefly. Snap's technical capability to detect speed and restrict speed filter use at driving speeds, and it didn't do that before November 2015. Again, it's their technical capability to do it. That's what he's testifying on as a computer science professor. He will testify about Snap's violation of recognized software engineering and app design ethics. And Snap spends a fair amount of time on that one. They seem concerned about that one. The limitations of the logging system Blizzard, including for its use as a forensic reconstruction tool. Technical inconsistencies between Snap's testimony about its app's capabilities and the behavior and record evidence. The importance of source code, and then the technical feasibility. I've bolded some of these. These are not bolded in the original. The technical feasibility of warnings and UI safeguards. Now, let's run through Snap's arguments kind of quickly. What is the relevant evidence? So Snap argues that the only relevant time period is an hour before and an hour after the crash. And fortunately, they played the excerpt from the deposition so you could hear them ask the judge, ask the witness, if you wanted to know whether she was using the app, what time periods would you look at? Well, yeah, that is the time period you'd look at. You wouldn't look at last Wednesday or a month before. You would look at the hour before, and you would look at the hour behind. But that's not the issue here. The issue here is that if you trust the spreadsheet, if the spreadsheet can be shown to be accurate and complete and not curated, and the point is it cannot. And the reason it cannot is part of what Dr. Bowie is here to do. He's here to explain that even if we look within the 4 corners, as we were saying, within the 4 corners of the documents, there are internal inconsistencies that cause one to question whether these documents should be believed over the presence of an eyewitness. He has personally analyzed the documents. He has reviewed testimony, particularly of Snap's 30B6 designee, Ms. Hayakawa, and of course his education, training, and experience. One thing that Naveen mentioned this morning, and I'll only mention it because I have it so the court can see it, is that McGee's data shows her in Griffin, Georgia, Huntersville, I think it's North Carolina, Nashville, Jacksonville, Texas, all within the span of moments, maybe seconds, maybe a few minutes. And Snap's 30B6 designee acknowledged that that is not possible. Now, she hypothesized that, oh, well, it's because we use IP address data, IP data to get our geo locating function for the app. And Dr. Bowie explains that that is virtually impossible. IP address data is not accurate enough. It's not reliable enough. It's GPS data. It was a mature technology at the time, and that's what it would be. So that means that this data in the city and region columns is without explanation. We don't know why this anomalous data is here. He analyzed the spreadsheet, and Naveen gave you round numbers, but he found 32 missing some gaps in sequence IDs in Kaylin Henderson's case. Spreadsheets, 272 in Crystal McGee. And in the various documents, you can see the numbers as they go down, 9,300 in Crystal McGee's from 2018. So a gap is, let's say you have 1, 2, 3, 7. That's one gap. But how many numbers are missing within that? And that's the column number 4. And the number is at 363,747 for Kaylin Henderson, 2,779 for Krista McGee. In other words, these are very large numbers. And the reason this is important is because these affidavits that SNAP keeps telling you about say that their data is more accurate than that of the phone company, or at least as accurate, and that it is impossible for there to be missing data. That if something happened on the phone and didn't get transmitted to the server because of a crash, it would be transmitted later, so there won't be missing sequence IDs. These sequence IDs are how you know the data is valid. Well, Dr. Bowie says, if that's the case, then we need an explanation for this, and there is no explanation. Oh, well, actually there is, and I will tell you what SNAP said. SNAP identified Krista Hayakawa as their 36 designee. And I'll pause to talk about that for a moment. You heard us being taken to task for not deposing Jack Brody or Tim Sane or Fong Lee. Well, what we did is we asked for SNAP to designate a person to testify on these topics. And they chose Krista Hayakawa. And in 2015, she was a rising, junior, senior in high school at the time. But she's the person that they put up to testify about these tech issues. And when confronted with the missing data, she gave us 3 options. One is there's data SNAP just did not choose to include in the spreadsheet. 2, events were lost between the phone and the server with no sequence ID and no event. And 3, SNAP's data repository did not store all the events. But don't take it from me. We're going to play a section of her video deposition. I hope the volume is up, Judge.
It is.
And here we go. Now, if someone were to say that the records were complete, you'd have to say that is not correct, right?
They're complete in that all of the data that falls, right, all the data that we tried to get has been given.
So the data that is not here is data that SNAP did not try to get?
Objective form.
Yes. Yes, that's one possibility.
What's another possibility?
Where we discussed how events can be lost between the phone and the server.
Okay. So either events are lost between the phone and the server with no sequence ID and no event, or this data that SNAP just didn't choose to include in the spreadsheet. Is that fair?
There's another possibility here, and that's where we got this data from didn't preserve all of the events. That could be a third option.
Okay. That's not the same as complete, is it?
Objective form.
I would go back to my answer that it's everything that we could give you, we gave.
Okay. Okay. So the judge has heard staff advocate this position at every informal phone conference, every hearing, every opportunity, and perhaps this is the first time you're getting to see why we have so stubbornly refused to accept the spreadsheets as the gospel that SNAP says they are. Dr. Bowie is here to talk about these issues, to educate the jury about these issues, and to explain to the jury that from a computer science perspective, from a software design perspective, these raise serious questions about whether this data should be believed as complete as the final word over the testimony of one or two eyewitnesses. Okay. Here's another interesting piece of evidence. On May 15, 2018, the Clayton County DA, an investigator for the DA's office, contacted staff. And this is not incidental, this is actually in connection with the McGee case. And he contacted Snap and said, I'm looking to get information on a Snapchat account, but before I send a search warrant or subpoena, I would like to know if Snapchat would be able to tell me if the user was on the speed filter on a Snapchat account during a certain time, even if the person did not post anything at the time. For example, if I was on Snapchat and I used a speed filter application but did not post it, would that activity be recorded by Snapchat? And would it be available for review? And a Snapchat agent responded and said, of course, we need legal process, yada, yada. But the last sentence, if the filter was not applied on an image and posted, we would not have a record of it. Shortly after receiving this, I think within a matter of a couple of days, the case against Chris McGee, the criminal case, was resolved with what I as an advocate could call a slap on the wrist. The story that Snap is telling the court and would like to tell the jury is the exact opposite of it. Because Snap is saying that no matter what happened or did not happen, we would know. We would know. Even if a person accessed the speed filter and did not post it, we would know and we would have a record of it. That's two irreconcilable stories that Snap would tell the jury, and that we have retained Uber Boy to explain from the perspective of a computer science professor is problematic. So Dr. Bowie has taught software design ethics for more than 20 years. We're going to talk about ethics for a moment. And for many years, this has fascinated me. And I look to see, is there a term for this rhetorical device, this argument style, this technique? And the closest thing I can find is moving the goalposts. And I'll give you an example that applies to this case. You get an expert who has specialized knowledge of software design ethics. And Snap would say, yes, well, or the person arguing would say, well, he had no role in creation of the ethical guidelines. Well, he teaches, what if he teaches the ethical guidelines? Well, he teaches them to students and not to industry professionals, because these are arguments Snap has made. Yes, well, okay, so he is a computer guy, but he didn't create the ethical guidelines. Well, he teaches them. Well, he doesn't teach them to industry pros, he teaches them to students. But I took note of something Mr. Masterson said in his remarks this morning. And that is that these apps were designed by people who went to good colleges. And I think that is a relevant statement, because the students that Dr. Bowie teaches go out into the profession and they design the apps and they design the software. The requirements for qualification of an expert witness are minimal. Generally, nothing more is required to qualify an expert than evidence that the person has been educated in a particular trade or science profession. And in this case, Dr. Bowie is not only educated, he teaches in the field. And the fact that he has not designed the app for release into public, and I'll talk about that in a moment, or the fact that when he teaches its students and not industry professionals is a matter that SNAP can use to argue before the jury, but it doesn't go to the admissibility of his testimony. And let's talk about that's a good segue. SNAP argues that Dr. Bowie never worked in the social media and variations of that, never designed a social media app and so forth. But as a threshold, SNAP does not describe itself as a social media company. In its 10K report, which was Exhibit 17 to Mr. Cheek's 36th edition, SNAP Inc. describes itself as a technology company. Their flagship product, Snapchat, is a visual messaging application. They built Snapchat as an antidote to the contextless communication that has plagued, quote, and the quotes are there in the original, social media. So you can imagine them putting up finger quotes to say social media. They've identified their competitors, and some are social media companies and some are not. Google, Apple, Kakao, Line. Kakao and Line, because I believe those are Korean or Asian communication platforms. Snow. These are who they say that their competitors are. But when we come into the courtroom, Snap says, well, he does software development. How about app development? Well, how about social media app development? And it gets more specific. It gets more specific. It gets more specific. And if it's social media app development for commercial use. And then they even said in their brief, by a company like Snapchat. These arguments are all well and good, and these are all things that they can use to cross-examine the expert, and maybe the jury would agree that the expert isn't close enough to be persuasive, or maybe the jury would disagree, but these are arguments for the jury. These are not arguments that prevent this man from coming in and testifying to the jury. As I prepare to wrap up, I'll hit several miscellaneous things that they put in their reply that we got, I think it was on Friday. Well, actually, no, I'll talk about these first before we do that. There are several kind of minor points that they make in their brief, at least from my perspective. And one is the so-called power loss scenario. Snap's designee, I think it was either Tim San or Fonnelly, one of them, probably Tim San, said that in the event of a power loss, that would not result in a failure of the app to transmit data. That's Snap's affirmative argument. Dr. Bowie simply to educate the jury and help them understand this conflict between the data and the eyewitness testimony. He says, well, here's one scenario where it could happen. He's not saying it did happen because none of the data we have from Snap will prove or disprove that, and we all know that the phone is no longer with us, and the court has an order to that effect. But he offers this as a theory, and he does not tell the jury this is what happened. But he says, jury, as you consider this statement by Snap, here's just one example of a scenario where this could happen. And he is authorized to give a theory without saying this is what happened in this case. Snap talks about Dr. Bowie on warnings. We have made it very clear he's not here to testify about the sufficiency of warnings or whether the warnings would have had a different effect. As I read and as the court read earlier, he is here to talk about the technical capability of Snap to insert warnings into the app or to take other actions to discourage misuse of the app, such as, limiting it at a certain speed, because he says Snap had the GPS data and it would be very simple programmatically, technically, to limit the speed in certain apps. And then later evidence bears that out because they did. And so he is talking about what they could have done. And there was one reference in the reply that he didn't talk about whether, or he doesn't have a basis to find whether Snap to tell whether someone was in the passenger seat or the driver's seat. Well, he's not here to talk about that. He's talking about whether it's technically feasible to either insert warnings, different types of warning or different types of control mechanisms to limit the harmfulness of the app. He is not here to testify about witness credibility. And as we saw in the description of his opinion, he is saying that the witness's testimony and the technical capabilities of a software app like this do not align. And it's based on his review of the facts in this case. So for example, if Snap's witness said, we use IP address data, you say, well, wait a minute, Snap sells geolocation services so that if you go to such and such Trader Joe's, you can put up a banner that says Trader Joe's or whatever the case may be. IP address data is not accurate enough to do that. And he's saying as a technical matter, this testimony is inconsistent with the facts. That's what he's here to do. In fact, there was another point where he was asked whether one of the witnesses was lying, or he said, I'm not here to talk about that. But we put that in. And then finally, he's not here to talk about Snap's response to complaints or concerns about the speed filter. The way that came up is that he was asked whether he did a feasibility study. And of course, he was not able to go back to 2013 or 2014 or early 2015 to do one. And he said, you don't have any idea what a feasibility study or a public forum or a focus group might have shown. And so I asked him at the end, well, if there was evidence that people called Snap to complain, if there was evidence that there were quite a few people who called Snap and said this speed filter is a death trap, this speed filter is lethal, you should remove it, does that give you any indication of what a focus group might have shown? And he said, well, yeah, that does give you some impression. That's what he says about the complaints and concerns. So Snap's reply, which we just received the other day, of course, we're not complaining about it, but it's just a matter of how much time we've had to review it. They make several contentions that I just have to quickly correct before I sit down. One, they said Snap voluntarily and immediately provided plaintiffs with Blizzard user data for 52 hours. That's not the case. Back in 2016, Snap said, well, tell you what, we'll show you some data, some spreadsheets, but you have to agree to this confidentiality. And if we send it to you, you got to delete it. And in fact, Mr. Neff was never allowed to see it because he didn't agree to the confidentiality. So it was a very, very curated and very limited preview of the data. Snap also says in their brief, a delegation of plaintiffs' counsel traveled to California in June of 2016 to meet with those Snap executives and software and data engineers and spent multiple hours having their questions answered. Well, it was a highly curated interview. Questions and views submitted to and approved by counsel in advance. No notes allowed. And I know this because I was there. Naveen and I were there. In fact, Naveen and I are the only people in this room who were there. And Naveen is left, so I wish he was here to bolster my recollection if needed. But they met after the answer, had the ability to question Fong Lee, Timothy Singh, Blair Mason, and Jack Brody. That's not correct. Fong Lee was there. It was Fong Lee and a bunch of lawyers for Snap. The meeting was initially going to be at the Snap headquarters, and you could have asked questions of whomever. And I think after we arrived, we said, actually, no, we're going to do it at this hotel, the conference room. So I don't want the court to be left with the impression that Snap just lavished us with data free of constraints. And despite that, we stubbornly persisted with the case. And as you can see, by stubbornly persisting with the case, which we did because of the concerns and the questions we have now seen that the curated data is one thing, but the full data raises a lot of serious questions that we think the jury should be able to wrestle with. Now, Snap complains, and I talked about this a moment ago, that we didn't depose these affiants, but we asked them 36. We asked Snap to designate and prepare a witness to testify in a way that would bind the corporation. And they gave us Krista Hayakawa, whom you saw a few moments ago. Now, Snap says Bowie does not challenge the witness's testimony or the data pointing to evidence or analysis showing any relevant user data is missing from the Blizzard data. So the 6 million line items missing, sequence IDs missing from the data, the 3,000 missing from the Ds, including some on the day of the crash, but not in the hour. According to SNAP, it's not relevant. But as we mentioned to you, as we argued to you a few moments ago, it is relevant if SNAP is offering these spreadsheets as being uncurated, as being neutral, as being unimpeachable, and being gave you some terms a few moments ago to overshadow the testimony of an eyewitness. Let me move through these a little quickly. I don't know if these will be substantive for the court, but they say that we complain about SNAPs using Blizzard, but we don't complain about Blizzard. We're just saying why Blizzard is not reliable. And in the interrogatory responses, it sets it out. Blizzard data is not analytics, is analytics data, not operational data, and that it's used for different purposes that don't require the same type of pinpoint and unerring accuracy. So as a foundational matter, analytics data, according to Dr. Bowie, is not as trustworthy or is not designed even to be as perfect as operational data. They say he points to no literature, nothing in the public domain, I guess. But Blizzard is Snap's proprietary software. There is nothing in the public domain about how it works. The people who know how it works are Snap's data engineers. Moving. Snap, I talked about some of this already, so I'm trying to, whatever we can do to shave off a minute or two. Yeah, there's a statement in the reply that Dr. Bowie admits in his deposition that he has no opinion inconsistent with Fongley's affidavit. And in support of that statement, they cite Exhibit 11. But Exhibit 11 is the affidavit. And they don't cite in the reply where Dr. Bowie admits to having no opinions inconsistent with Fongley. And the last quote, and then I'll sit down. It says that Blizzard, Dr. Bowie says that Blizzard is not a reliable forensic tool, but that is unsupported by any reference other than what he personally thinks. And they give you a citation 220 lines 23 to 20 to 221.1. But the very next lines said, he is asked, and if I understood you, the heart of that reservation is gaps in sequence IDs, right? Right. The duplicate numbers, the gaps, the missing numbers. That's right. So this is Dr. Bowie coming in and saying what he personally thinks. He actually reviewed the data. He actually found gaps in the data. He explains that from a software design standpoint, from a computer science standpoint, if you have this much data missing, that raises questions about the integrity of and reliability of the document. And that is the testimony he offers based on education, training experience, as well as its firsthand experience with the evidence in this case. Judge, I'll sit down. Any questions?
Yeah, you all did a good job on this one. So, all right, response from the defense.
Yes, Your Honor. So again, the good news is that a court reporter showed up and recorded this on video and wrote everything down. I'm not going to take the court's time going through those things, but I would never represent the court that I asked the man, do you have any opinion to a reasonable degree of scientific certainty that something Mr. Fong Lee said is inaccurate? And he said he did not. So and it's cited in our brief. I agree that Snap says it's a technology company because it is. In fact, I think that their position is and remains, right, that they supply an app that it's not mandatory that everybody in the world download it, and that people have personal responsibility. But to the extent they're a technology company and not a social media company, a distinction certainly without a difference. He never worked at a technology company in the last 40 years either, Dr. Bowie. I mean, the power loss scenario, they throw it back. This is what will happen if he's allowed to give opinions to the jury and they're allowed to argue about their experts' opinions. I asked him about the power loss scenario, and he said he has no basis to say that's what occurred here because the witnesses didn't testify to that. The Blizzard data and how they got it, there's an affidavit from Mr. Trigg, who was the attorney who preceded us, about this meeting. They went out and they met at a hotel in the middle of Snap's campus, and they didn't depose the people after. They either accepted that testimony or didn't want to have it be of record beyond the affidavits. The idea that somehow SNAP is hiding something from them is not true. They misstate what Krista Hayakawa, as the representative, said. What she's being asked about is user data, right? There is absolutely all kinds of data that's kept on servers that has nothing to do with whether the person opened the app or not, as an example, right? And so what she's explaining is that there could be some type of event where the phone is damaged or something like that, where it doesn't transmit the data. But we've already been through that. We asked Miss McGee, and there is no damage to the phone or anything that stopped it from happening. We know that the other passenger in the car, Miss Henderson, I think that's her name, testified that she did pull up the speed filter, and we know it transmitted to the Snap server. So the theories that when I test these theories with Dr. Bowie, he admits that he doesn't have evidence. But if you let Mr. Adams, who's a very good lawyer, right, stand up and throw out these wild accusations as theories, he says, well, you can have multiple theories. You don't have to prove them. No, you do with an expert. Otherwise, it'll be given the weight, or the jury might reach the conclusion with no support whatsoever in the record supporting it in the way of evidence or testimony or documents, that that's what happened here. And that's why this gatekeeper role is so important. We're not asking for the spreadsheets to be taken as gospel. What we're asking the court is, when we tested their experts about the reliabilities of these spreadsheets, Mr. Persinger, which I'll get to in a moment, and Dr. Bowie, neither of them had any evidence whatsoever to base any opinion that Snap manipulated it, changed it, cheated, lied, whatever you want to say about these spreadsheets. When you look at the spreadsheets and you ask him, what is it about them that you think concerns you? He says, well, these sequence IDs, there's some missing. And yes, he ran a software thing that throws up numbers of missing sequence IDs. But then I asked Dr. Bowie, okay, well, what do you think it means? Oh, I don't know. Okay, well, what's relevant? Well, what's relevant is whether the data on the night of is in question. All right, and your concern is there's missing sequence IDs, gaps, or duplicates. Yes. Are they any in that period of time? No. Using his methodology, he answers the question in our favor, and the plaintiff's lawyers should be entered, saying they can't make a different argument to the jury or have him testify about theories, educated guesses. That's exactly why Daubert requires that opinions and arguments about opinions of experts be excluded when they can't give a scientific basis and then support that following that methodology. He's very honest, and he agrees that he can't. The J.B. Hunt opinion is not applicable here. It was an opinion that it was he gave an opinion that something was foreseeable to a reasonable degree of certainty, and he was qualified as an expert to do so. That's missing out of the analysis here. Speaking of qualifications, I pulled the jury charge, right, for strict liability design defect, because maybe we need to be specific about what the jury will be asked here. It's pattern charge 62.640, right? Ends with, the manufacturer has a duty to exercise reasonable care in choosing the design for the product. That is specialized knowledge. That is specialized knowledge to be that designer. He says, well, he's teaching in education and they got education. What he doesn't say is that Dr. Bowie says he's not a data engineer. He's not an app scientist. He's not all of these titles that people at Snap have. He's never had them in his life. And he doesn't have specialized knowledge as it relates to the standard of care that applies in industry. That he could have said things like, other people in the industry were doing this, but Snap didn't. And I'm familiar with that. He could have said, here's a publication, or here's an industry letter where members of the industry weigh in on this. He didn't. He provided no basis to be able to offer that breach of the standard of care opinion. And to the extent that the jury is going to be read this jury charge, Dr. Bowie is not qualified by his admission. Related to publications, which Dwayne points out a number of publications, I asked Dr. Bowie, I said, publications. Do any of these publications on your CV, pages long, right, have anything to do with your the substance of your opinions that you intend to give at this trial? No. Okay. He mentioned Louis Brisbois. He has been qualified as an expert in trade secrets and intellectual property cases, but the substance of that testimony is vastly different than what he's offered here. Again, I would just point the court to his testimony about warnings. They try to mix that with some sort of technical capabilities around geolocations, that function of the app where they're talking about, like, I guess it'll know if you go into Starbucks or whatever, right? So it can give you an ad for Starbucks. I think it's what the suggestion is. That did not exist in 2015. It's irrelevant to the analysis here. The plaintiff's lawyers keep suggesting that this idea, right, without support, that the spreadsheets aren't reliable because Snap did something wrong or manipulating them. They keep throwing out things like, well, this geographic location shows that she was jumping around to different cell phone relays. And that's been explained by these Snap witnesses in detail. And it has absolutely nothing to do with the question before the court that needs to be decided is the user data reliable for the users, I guess I would just say, in that car, right? And there's no question, right? They keep saying, well, they won't tell us about their BigQuery and all this stuff. That's just not true. If one were inclined to watch all 30 hours of Snap depositions, you would find that they testified very clearly and very succinctly that what they were trying to pull was fields of user data. They're like, well, they didn't tell us what they searched for in the BigQuery search. It's right there in the fields. Open app is an example. Close app is one. Scroll the carousel. We went through this protocol with the court, just like they went through the protocol of going to California and interviewing Fong Lee with the court. It was agreed on. The protective order was agreed on by everybody but Mr. Neff. And so he didn't get to look at the data. That's on Mr. Neff. And I respect him for it. But the plaintiff side got to look at the data, right? Okay. So at the end of the day, when you allow all of these things to be thrown out here without any support or without any fit to the question the jury has to decide, there's nothing it can do. It can't answer any questions. There's nothing it can do except for prejudice my client. And so I move again, Your Honor, that Bowie's opinions be limited or excluded entirely. And also that to the extent that the court enters an order that any arguments making these suggestions without any support in the record factually or from an expert should also be, should end. Thank you, Your Honor.
All right, thank you. All right, any last words?
I'll break the mold for today, just offer 3 comments. One, I just reminded that we have a general negligence claim in addition to products and strict liability. And I also mentioned with BigQuery, as Mr. Masterson pointed out, we do know what they presumably searched for because it's in the spreadsheets. What we don't know is what they did not search for, what they did not provide. And you saw the video, Ms. Hayakawa doesn't know either, and she's the 36 designee. So that's all I would add. It's the problem we face. We know what they did give us. We don't know what they didn't give us inadvertently or otherwise. That's all.
Okay, so that closes out Dr. Bowie. So we started out this morning with the motion for summary judgment outstanding. We've checked that box. We dealt with both of the sealing motions. Y'all are good with those for now with what we discussed.
Sure.
We finished Mr. Alter. We finished Bowie. And that leaves us, in my mind, 2 remaining ones, which is Persinger and then the Harbin, Snyder, Giles combo. Give me your estimates because it's 5 o'clock. I'm just trying to figure out what my options are. Nobody likes going late, but sometimes it's okay if you think you're going to knock it out. So, but at the same time, you know, we have the court team here who have to stay late with us, whether they want to or not. So. Oh, yeah, we're going to take a break here in a second, but you're good. No, I'm saying go, but.
The Persinger argument is 5-ish minutes.
Okay.
It's not very complicated or long, nothing like the ones before it. I can't speak to the other one. I'll defer.
And if I had to estimate for the Harbin, Giles, Snyder, I'm thinking maybe 20 minutes total.
Because I was thinking if we could finish by 6, that would be about right. What do y'all think?
20 minutes by you or
Yes, 20 minutes on his side is what he's saying,
I see.
which gives y'all about 20 minutes.
It might be 15.
And that gets out of here. Unless y'all have a longer estimated time.
I mean, one suggestion, Judge, is we do Persinger and see how long that takes and reassess.
Okay. All right. Well, let's do this. Quick bathroom break. Everybody stretch your legs and we'll jump back into Persinger when we get back. All right, so it's 5:14. We have two matters left. If we can finish.
On the floor.
Okay, all right, so, so our rules of engagement with the courthouse have changed a little bit now because we're after hours, so we just have to stay on this floor because Piper has to be able to say he kept an eye on us. Because everybody else is going home and heading out, so,
We're the only ones here.
okay. So the goal is to finish close to 6 as possible. If we go a little over, that's okay, but if we go a lot over, then we'll need to come back tomorrow morning, which none of y'all want to do. But if we have to, we will. So, but at the same time, I think we are close enough to get this over the finish line. All right. So, what do y'all? Let's go ahead and do Persinger next because that's the quickest. If that is okay.
Sure.
All right, then Persinger it is, and floor is yours.
Okay, we're on the record. All right, may it please the court, as briefly as possible. So, Your Honor will recall that Mr. Persinger, I have no quarrel with his qualifications, but I have a little bit of a quarrel with the nature of his sort of be the plaintiff's pocket expert guy. So he originally looked at the cell phones. That part's non-controversial except for the end, but that he analyzed the cell phones he was competent to do. We agreed. I think we even split the cost of it. At the time he did the cell phone review, for the record, Blizzard data existed. So did the track phone records. At no point was he disclosed as an expert beyond cell phones. The plaintiffs, as you've heard today, had Dr. Bowie review the Blizzard metadata. He gave opinions or purported opinions related to that. We hired an expert who testified related to in response to Dr. Bowie, and then they disclosed as a rebuttal expert Mr. Persinger, and his purported opinion was that the spreadsheets, the Blizzard spreadsheets, don't have any value. His second opinion, which is consistent sort of with what he said throughout, was he talked about the evidentiary value of the telephone and what he thinks might have been on it or not. Whether I agree or disagree with him, I think that was a fair game in terms of a rebuttal opinion. The other one was not, right? He says, well, I don't think that Excel spreadsheets are reliable. Okay, well, did you look at the Blizzard Excel spreadsheets? No. Do you have any specific criticism about them? No. So all we want is an order that says, without doing any review of it, and because he is cumulative anyway of Dr. Bowie, and could have been disclosed originally to do that instead of Dr. Bowie, that he be an order preventing him from giving any opinion about the Blizzard data that he did not review. Secondly, and lastly, the pocket expert also, after not disclosing it through a hearing, 2 rounds of expert disclosures going back and forth, provides an affidavit, purported expert opinion, in response to the motions that were filed here, including summary judgment. And what he does, in short, is talk about the track phone records for Miss McGee. I'm told that those have been produced since around 2017. At all times, if he had any opinions about them, they should have been disclosed timely. Discovery's closed. They shouldn't be attaching that as expert opinion, new expert, undisclosed opinion. It shouldn't be considered as admissible evidence to defeat summary judgment. If you disagree with everything I say, Your Honor, we'd at least appreciate the opportunity to depose him. Thank you. Any questions? If not, I'm done.
Let me just repeat that back to make certain I've got it. Actually, let me hear their argument, and then if I still have any issues, I'll circle back.
Sure.
Thank you, Jim.
You need it.
Oh, yeah, screen if I might.
Source code?
Yep,
Okay.
and we use the slash and burn so we can shorten this up. Source code and schema. Source code is something that I don't think any of the experts in this case disagreed. This would be probably the best evidence to understand what the app is doing. In other words, the source code gives you line by line the instructions as to what makes the app operate, what it does, what it records, how it behaves. Schema is something that Mr. Freemeyer, who we talked about for a bit, introduced. And schema is like a roadmap. It tells you how the database from which Blizzard is drawn, how it's structured, what the column headings are, what data you should expect to be in there. Mr. Freemeyer testified that the schema would be one of the best sources of evidence about what Blizzard is supposed to capture. And I asked him, if you want to know all the field types it was designed to log in September 2015, what would be the best source of evidence? And he says, one of the best sources, and probably the best, is the schema. The schema is a description of how a database is structured, and it's normally, there's normally documentation about the schema that's separate from the actual source code. And I asked, did you have an occasion to look at the schema? I did not. Did you ask for the schema? I did not. Have you looked at schema in other cases? I haven't. He then talks about the forensic procedure he would follow. He said, he testified that after understanding the schema, he would typically seem to understand the process of pulling data. And then he would witness the data extraction and he would document it. And in his words, he said, I normally interview the data administrator. I inserted the word data. He says the administrators. But I would normally interview the data administrators that understand how the data queries can be performed. And again, this was the process of getting the data out of BigQuery. And he said, and then I sit and observe the query process, and I document the query process. So I normally don't run the queries myself, but I make them step me through it step by step. And I take screenshots so that I can have it available to present to the court at the meeting. And I asked him, were these procedures available to you in this case? I said, these procedures were not available to you in this case. And he said, that's correct. What happened in this case is that gave him the spreadsheets. And then said, you can talk to, here's some people you can talk to, council set up meetings, council attended the meetings, et cetera, et cetera. But he was not able to do that forensic process he described. Despite this, he offers two main opinions. The first is that Snap's data is good and it proves that McKee was not using Snapchat. Oops, excuse me. And the second is that Snap's data is so good that the phone wouldn't add anything to the evidence. These are my words, but I think it's an accurate reflection of what he testifies to. And Jim Persinger rebuts these two opinions. Freemeyer says, and again, my words is not a quotation from his deposition, that his data is good and proves that she was not using Snapchat. And Persinger says the absence of proper forensic procedure leaves us with Excel spreadsheets that cannot be relied upon. In fact, he said an Excel spreadsheet is like liquid. Mr. Freemeyer, again, in my words, Snap's data is so good the phone wouldn't add anything to the evidence. And Persinger says the phone is a repository of significant data beyond what the app could capture. So Snap's challenges to Persinger are that he didn't examine the Blizzard spreadsheets, but we didn't ask him to examine the output, that is the spreadsheet. We asked him to critique the process. He testified, I did not analyze the Excel spreadsheets, nor would I. And the reason he would not is because the spreadsheet is completely changeable, it's fungible, it's, in his words in the deposition, it's like liquid. Snap says that Mr. Persinger is not a rebuttal expert, but he is in fact. In addition to testifying to the forensic process and conclusions arrived by Freemeyer, he rebuts Mr. Freemeyer's testimony that the phone would not be useful. And if I hope I'm not reading too much into it, but I think Snap is not vigorously contending that that is inappropriate. So I'll move through this quickly. But the first time in the deposition on April 16, 2026, when Mr. Freemeyer offered that opinion, and we promptly brought in Mr. Persinger. From our perspective, Mr. Persinger's involvement in the case could have been done when the court issued its order. But since this issue has come back up, we had to bring him in. We could not have foreseen the need for that testimony. Now, there's the last thing was that his testimony is duplicative of Dr. Bowie's. And I cite a couple of cases. Since there's no Georgia case specifically on point, we zoom out to the Northern District, which the court might consider as persuasive evidence. And in that case, it was a sex trafficking case, and there were two witnesses who testified about the effects of sex trafficking. One, I believe, was a counselor or a psychologist, and one was a trafficking expert. And they were sought to be excluded because they're finding on the same thing. Well, the court said it may be true that both experts touch on these topics, but the court notes that testimony on the same topic by different experts is not neatly cumulative, where the experts will testify from different professional perspectives. In other words, they have different credentials and they offer different perspectives on the impurity issue. This is a different case, even though they ultimately reach the same conclusion. Thus, their testimony is not cumulative. That's the United States v. 796 F sub 3rd. I believe we cited that in the book, so I'm just moving quickly through it. So finally, in the Northern District case, the court said these challenges are premature prior to trial. Prior to trial, the issue of whether an expert's testimony may be cumulative is largely speculative. And that's why challenges to cumulative testimony are best made at trial so the court can ascertain whether evidence is in fact cumulative. Since this is kind of a combined argument, I'll talk for just a couple of minutes about the track phone issue. Our pocket expert, it sounds so pejorative, even though I know it's not. But on April 8th, Ms. Gower circulated the track phone usage history for McGee. On August 6th, SNAP's 30B6 designee, Nona Yadigar, was testifying to the quote-unquote universe of data supporting SNAP's contention that McGee was not using the app. And we'll run through. SNAP has, and I bolded in red what she listed. SNAP has internal data and metadata, yes. McGee's sworn testimony, yes. 2 witnesses in the vehicle, yes. And Mr. Neff persisted. What other facts or evidence does SNAP have? And we can scroll down to the highlighted phrase. That is the universe. So there's no other facts or evidence on that issue, right? On that issue of whether she was using Snapchat at the time of the accident, correct. So that was our opportunity to question SNAP as to its position via 30B6 testimony in August of 2024. On August 16 of 2026, we deposed Mr. Friedmeier.
April.
I typed August, it's April.
April, okay.
Yeah, just a couple, we deposed him in the future. He has no opinions regarding the track phone. In fact, he opines that SNAP's Blizzard data gives him all he needs to opine on this issue. April 21, Ms. Gower recirculated the same track phone data she sent in on April 8 of 24, and she said, I know this has been passed around in the defamation case. In this case, I just wanted to know if y'all wanted this formally supplemented. If so, I'm happy to do so. On April 27, we identified Mr. Persinger to rebut Mr. Freemeier's 2 stated opinions. And then on May 11th, for the first time, SNAP in its motion for summary judgment argues that the track phone, cellular phone, call detail records do not show McGee was using her cell phone at the time of the crash. And so for that reason, we asked Mr. Persinger to file an affidavit in support of our response in opposition to summary judgment. That's why that is before the court. I don't know that there's anything else to be deposed. Certainly there's no basis for striking his testimony. In fact, I believe that would be reversible error under Georgia laws that applies to expert testimony or witness testimony that one party contends is untimely. So with that, I'll turn over the floor back to Scott, unless the court has questions.
No, so far so good.
Well, it's not reversible error when the court enters a scheduling order and says you got to disclose your experts by a certain date to exclude late filed affidavits with new opinions. Let's be clear. I want to say this. In terms of reasonable foreseeability, the most disingenuous thing that's been said in this court today is that these lawyers did not foresee the need to have somebody challenge the SNAP Blizzard data. That's asinine. They've been complaining about it since 2016. Okay, and so the idea that they wanted to challenge the spreadsheet or it wasn't available to them to give to Mr. Persinger as an original expert is just simply false. They had the data. They've been fussing about it since the beginning of time. They hired an expert, Dr. Bowie, to analyze it. He is their expert that they disclosed. I don't know if they didn't like his opinions or what, but nothing changed about that. Freemeyer responded to Dr. Bowie related to the reliability of the data. That's not grounds for a rebuttal opinion. And even if it was, even if I'm dead wrong about all that, he has to at least read the Blizzard data, right? Before and give some specific reason that's wrong with it. All he said was, I'm critical of the pool of the process, which they've also been critical of since at least 2016, right? This is not new. This is not something they had to rebut. The disclosures of experts, they've had this track phone data since 2016, 2017. A fact witness or a party witness is not required to know all the evidence in the case, right? The way you find out about evidence in the case is discovery. And you know where they got it? They got it from a third party request that one of us as parties made and attached it to a motion many, many years ago. To the extent it wasn't attached to a motion many, many years ago, which it was, they had the power to ask the cell phone manufacturer, just like everybody else in the case. Snap doesn't have to do that to figure out whether it existed. They did not do that. This is a new opinion. It's not a surprise. And at a minimum, we ought to get to ask Mr. Persinger questions about it. Related to the one thing that I want to correct for the record, and I'll sit down. Mr. Adams said that we don't challenge what Mr. Persinger said as opinion one in the rebuttal. That opinion was the cell phone contains more information than the Blizzard data. And he said would contain, and what he wrote up there to the court, that's not Mr. Persinger's testimony. He said it could have more information. And the other thing that's important is that he recognized when his deposition was taken that there are things that could happen to a phone in 10 years, including, as you saw from Ms. McGee, continuing to use it, that would overwrite or eliminate that data in addition to the Blizzard data being present. And just sitting there in a safe or whatever and not being used for 10 years could do the same. So I didn't want it to be left unchallenged that we do challenge his opinion when you focus on it related to additional data being on the phone. He did not say more likely than not it would be. He said it might be.
Okay. And again, I'll read them. I will read all these transcripts. I just want to remind everybody what's going to happen after this hearing. After this hearing, I'm going to pivot immediately into a trial, which will take a good week and a half of my life. And then we're going to have our summer lull where we only do very light court for the month of July so that the team can all go take breaks. My plan during that time is to dig into this case so that by the time y'all get me your proposed orders, I will have read all 12,000 pages of what you've sent me, and I'll be ready to pretty quickly sort through what you're sending me and get answers out pretty quick. So I just want to make certain you all know that there's kind of a method to what's happening here that y'all may not have known. You might not have had our court calendar memorized the way we do. So, okay. All right, let's pivot to the last grouping then. I'm so sorry.
Would you entertain it?
Yes, I'm sorry. Yes, you do have the right to go. A few more thoughts. So, and then Mr. Board, the floor is yours.
Thank you. I'll just remind the court that SNAP joined the motion for sanctions against McGee, so he should not be heard now to say, the photos in that court. In fact, when asked Dr. Bowie, couldn't the data have been lost on the phone over time? He said, well, none of this was subjected to extreme heat or some kind of unusual condition. There's been no expert testimony in the case that the phone was sitting there in a desk drawer with loose data. But the court has ruled on that already. And so I may have been heard to criticize Snapchat once or twice in this case. But in this case, I'm not criticizing the 30B6 for not knowing this fact. Sure that the 30B6 has an obligation to testify to data, to information known or reasonably available. What I'm saying is that on June 15 of, well, it was in August of 2024, that was not identified, the track phone information was not identified as a basis for SNAP's contentions. So there would be no reason for us to hire an expert to rebut a defense that SNAP was not making. And so as soon as that defense was made, we issued, we identified Mr. Persinger. We pulled him out of retirement, so to speak, from this case to talk about it. And then finally, as to these spreadsheets, he explains why he did not review the spreadsheets, because we didn't ask him to review the spreadsheets. We asked him to talk about the forensic process described by Mr. Freemeyer that Mr. Freemeyer followed, and which boiled down to, in his own words, that the spreadsheet felt right. He said that it felt right. And we cited that in the brief so the court could see it and then tried to put it in context so that it's fair. It felt right. And Mr. Persinger, we asked him to testify about that. And in the process of doing so, he's saying this is why you don't look at an Excel spreadsheet and say it feels right, because an Excel spreadsheet is liquid. And in order for it to have any reliability for the fact finder, you must follow the process, which coincidentally is a process that Mr. Freemeyer described as what he would ordinarily do. He just didn't do it in this case. So that's what Mr. Persinger is here for. Not a surprise witness, not a kind of a, hey, let's get another bite of the apple, but it was in direct response to Mr. Freemeyer's testimony. And in fact, it was within the time frame allowed by the scheduling order. We did it within just a couple of days and kind of expressed it so that it wouldn't be the last thing. So that's
One more round on this. Tell me again what it is you're wanting to, if I were to say, yeah, go depose him, give me that universe one more time.
Of what?
Of what you're want, if I say, go depose him again, what exactly are you wanting to ask him about? Let's make certain that what you're saying and what I'm understanding match.
As it relates solely to the issue of additional deposition, it would be the contents of the affidavit attached to the response to our summary judgment motion, not revisit his earlier opinions, which we may have challenges to, but we're not asking to redepose them.
Okay, I just wanted to make certain that's what I was thinking, but I wanted to make certain I wasn't missing it. It's been late in the day and I didn't want to guess. Okay, anything else on that? All right, is everybody good on that? We ready to go to the last topic?
Yes, sir.
All right. Am I correct in thinking we're gonna do all of these as one group?
Yes, sir.
And, okay, Mr. Board, the floor is yours. I guess you need the screen. You ready?
It's something.
There we go. All right, it's up on the screen.
Thank you, Judge. Judge, plaintiffs identified Dr. Harbin, a physiatrist, to testify about Mr. Maynard's recovery from the injuries that he suffered in the car crash. And during his testimony, he testifies about the fact that he cannot, because he's not a neuroradiologist, discern what cognitive issues arise from Mr. Maynard's traumatic brain injury versus other pre-existing conditions. So we want an order that just prohibits him from testifying about the thing that he said he can't testify about. With respect to Dr. Snyder is a neuroradiologist. Plaintiffs disclosed him to interpret Mr. Maynard's medical imaging. We're not saying he can't do that. We're not saying he's not qualified to interpret imaging. All we want is an order from this court that limits his opinions to that. Plaintiffs disclosed Shailene Giles to look at Dr. Harbin's 2023 report and prepare a life care plan, estimating what his future medical needs would be. And we have to move to exclude her life care plan, or at least limit it substantially, because her life care plan does not discern between the medical needs and care needs that Mr. Maynard will require presently or in the future. It does not discern between the needs that arise from any brain injury suffered in the crash versus needs that arise from his stroke and from his small vessel disease, which Dr. Harbin, on whose opinions Ms. Giles bases her entire life care plan, Dr. Harbin says, well, small vessel disease, that just gets worse over time. And as he's aged, all of his cognitive issues will just get worse over time. So that her opinion and her life care plan, it doesn't differentiate between the two of them. And under law, she's required to do that. And if her life care plan doesn't, it's deficient. and it needs to be excluded to the extent that it failed to do that. Now, the plaintiffs claim that they can link together the separate opinions of Dr. Harbin, Dr. Snyder, and Ms. Giles. But none of these witnesses can testify whether or to what extent the cognitive issues that Mr. Maynard is dealing with today and will deal with in the future are a function of the injuries he suffered in the crash in 2015, his advancing age, his small vessel disease, or a combination thereof. We know that we don't disagree. Dr. Harbin is qualified to diagnose a brain injury. Dr. Harbin testified, and you'll see up on the slide here, he testified that he would expect Mr. Maynard to recover from that brain injury to the extent that he can recover within a year or two. And he says down here on page 105 that probably the 2-year mark would be when Mr. Maynard would plateau. All right. Now, Dr. Harbin saw Mr. Maynard years later in 2023. So he's testifying that Mr. Maynard's condition and his recovery from his brain injury suffered in the car crash would have plateaued around 2017. And I'll represent to the court that elsewhere he says maybe even as late as 2018 or 19. Dr. Harbin saw him in 2023. Dr. Harbin acknowledges that Mr. Maynard has sequelae from both his stroke and the brain injury. Next slide, please. Dr. Harbin testifies that small vessel disease can cause the same symptoms as a traumatic brain injury. He says it here on page 20, as well as on page 21, that both can result in signs of cognitive impairment, balance impairment, and issues relating to cognition, memory, and balance. Dr. Harbin acknowledges elsewhere in his deposition that patients who suffered strokes can present with the same symptoms as individuals who suffer trauma to the brain, and that a brain injury and small vessel disease can produce overlapping symptoms. Next slide, please. Dr. Harbin testified that over time, Mr. Maynard's age and cerebrovascular disease would reduce his cognitive function. It says here we have issues to deal with aging. He's an older gentleman, and his risk factors for cerebrovascular disease would take away cognitive function over time. That time has elapsed. We are now 10 years since this occurred. And Dr. Harbin acknowledges elsewhere in his deposition that somebody who, like Mr. Maynard, has small vessel disease, over time with aging, we would see a decline in anybody with his condition. That over time, small vessel disease will cause worsening cognition, worsening motor function, balance, and movement. Next slide, please. Dr. Harbin testifies that a neuroradiologist, like I mentioned in the beginning, Your Honor, a neuroradiologist might be able to discern whether something that Dr. Harbin sees on Mr. Maynard's imaging relates to trauma or chronic issues like small vessel disease or a prior stroke. He testifies, and this is from page 104, he testifies, and I'm quoting, "We don't know what he, Mr. Maynard, would be like today had he never suffered the brain injury, because we don't know how his vascular disease would progress." That's what page 104. Next slide, please. And he says, sorry, one more. Dr. Harbin's opinions on causation, he examined him in 2023, 8 years after the crash. He testifies that traumatic brain injury symptoms will usually plateau around 2 years, at most 4 years after the injury. He testifies that small vessel disease can cause the same symptoms as traumatic brain injury, and that small vessel disease is both a progressive disease that gets worse with age. Dr. Harbin admits that he needs a neurologist to differentiate between brain injuries from stroke and small vessel disease versus traumatically caused brain injuries that would relate to this crash. Now, with respect to Dr. Snyder testified that he doesn't treat patients in a clinical setting in his practice. And it's for this reason that Dr. Snyder calls in his report for a clinical correlation of the issues he identifies in interpreting Mr. Maynard's imaging. Next slide, please. Plaintiffs appear to agree, stating in their response that Dr. Snyder chooses to leave the evaluation of the patient's clinical course and the diagnosing of actual symptoms to the individual's treating physicians. Dr. Snyder has never treated Mr. Maynard, never examined him, or reviewed someone else's examination of him. And when we deposed him, Dr. Snyder was not even aware that Mr. Maynard had been hospitalized with a stroke. In his report, Dr. Snyder stated that Mr. Maynard's symptoms relating to his stroke and small vessel disease were apparently clinically silent, but he admitted during his deposition on cross-examination that that was not true. And that's on page 88 and 89 of the deposition. Your Honor, we do not question Dr. Snyder's qualifications or ability to testify regarding his interpretation of Mr. Maynard's medical imaging, but that should be the extent of his opinions in this case. He should not be permitted to opine that Mr. Maynard's cognitive issues are caused by brain injury alone without contribution from small vessel disease, stroke, or concussion. Next, with respect to Ms. Giles. Ms. Giles, as mentioned, provided a life care plan, and it's supposed to estimate what his medical needs will be in the future. And to be admissible, a life care plan has to be based on admissible evidence. In our briefing, we cited two cases, the Hale versus Gannon case and the Hopi versus Spear case. And in both of these cases, the court pointed out the importance of the basis for a life care plan. In Hale, the life care planner included prescriptions for treatments that might have been related to impairments existing before the subject accident. And the court excluded those items because it wasn't clear that they related to the subject accident. Therefore, they weren't recoverable damages. In Hopi, the court said, if the underlying treatments are not proved by independent admissible evidence, then the life care planner's projected cost of treatment is irrelevant. In Hopi, the life care planner said that the plaintiff would need physical therapy for the rest of their life. And the life care planner based her conclusions on the report of a physician. However, on examination, the life care planner admitted the physician did not indicate to her to what extent he felt the plaintiff would need such physical therapy had he not had the accident. And to quote from that case, here, Ms. Giles bases her life care plan on Dr. Harbin's reports. However, next slide, please. Okay. Dr. Harbin said that we don't know what Mr. Maynard would be like today had he never suffered the traumatic brain injury, because we don't know how his vascular disease would progress. You were on the right slide. Dr. Giles didn't base her life care plan on any other doctor's opinions, just Harbin's. And like the life care planner in Hopi, Dr. Harbin cannot indicate to what extent he felt Mr. Maynard would need care had the crash not occurred. That's what he testified. So Ms. Giles' life care plan is therefore inadmissible. And unless the court has any questions, I'll sit down.
No, I see why these three are a package for the purpose. It would not have worked to try to break those three into three different groups. I appreciate that is what I'm trying to say.
Yes, sir.
The very short version is we don't want the jury to consider evidence about damages that weren't caused by the accident.
Sure. I'm tracking that, and I'm tracking how all three of those dovetail into the others. All right, thank you. All right, Mr. Neff, we've waited all day. You're up.
Yeah, I'll try and keep it calm, Judge. There is a lot of misstatements that you just heard about what Harbin can and cannot do. In fact, the first time they filed this motion, they said he was not qualified. And this is a man that's triple board certified, including the treatment of traumatic brain injury, and also has a PhD from Georgia Tech in biomechanics. So if anybody in the state of Georgia is qualified to talk about the injuries caused by trauma at high speed wrecks like this one, it's Alan Harbin. Having said that, Harbin said the majority of the symptoms are related to the brain injury on page 80 and 81. What the defense is trying to do is exclude him because he doesn't have a crystal ball, which is absurd. That's not how medicine happens. That's not how doctors treat people. I don't walk around with today I have a 98 brain function because of lack of sleep and caffeine. And then if I get hit by a truck at 72, that's not how doctors are able to assess functionality. But Harbin said the majority of the symptoms are related to the brain injury. He said that Mr. Maynard would be significantly better had he not had the traumatic brain injury. He said the primary cause of the cognitive decline found in the neuropsychological testing, not mentioned at all by the defendant's counsel, is due to the brain trauma. He said the brain injury is the primary cause of the problems. So Mr. Bohr would have you believe that Dr. Harbin can't say anything about what is what. And it's challenging, and the only medical doctor expert that the defendant identified, Dr. King, admitted to such, that it's very difficult to tease these things out. But here's the truth of the matter. Shailene Giles, when she did her life care plan, said that it relates to the traumatic brain injury because his functionality before getting involved in this wreck was 100%. He was working as a Uber and Lyft driver. He was taking care of all of his activities of daily living. He had been seen by doctors in 2015, and none of them said that he had continuing symptoms of stroke. And what the defendant did in the cross-examination of Snyder is say, hey, look at this record from January of 2015, where Mr. Maynard went to the hospital with gastroenteritis, an inflammation of the stomach and intestine. And in his history, it said, well, he had a stroke in 2002, and he was left with right upper extremity weakness. But that was in 2002. None of the records in 2015 say that he had right upper extremity weakness. And therefore, all of Nurse Giles's life care plan relates to care for the traumatic brain injury suffered by Wentworth Maynard in the wreck of September 10 of 2015. And turning to Dr. Snyder for a minute, Dr. Snyder said there is a hole in his corpus callosum on page 162. And the major function when you have a significant injury like that is a loss of cognitive ability. He said that on page 168. And when Dr. Snyder was asked, hey, do you see any evidence of vascular disease in the corpus callosum on page 172, starting on page 169, he said, no, I don't. And when we deposed Dr. King, staff's only medical expert, I said, are you going to give an opinion as to causation? Are you going to give an opinion as to symptoms? He said no. So what are we left with? We're left with exceedingly well-qualified experts, triple board certified PhD in biomechanics, saying the majority of the symptoms are caused by the brain injury. The fact that he doesn't have a magical painometer to say, oh, well, he might have been 1% impaired because of this stroke. We don't know what would happen 10 years later. That doesn't mean that his opinions are not admissible. The testimony that he gives about his examination of Wentworth Maynard goes far beyond what he would do as a treating doctor. And he points out in the subsequent MRIs that hemosiderin is left from the trauma of 2015. So that's a marker of blood and iron that shows remnants of the extreme physical trauma. Mr. Maynard was in the hospital and rehab facilities for 71 days after this wreck. And the defense wants you to think that none of this can be tied to the brain injury with a substantial degree of medical certainty. That's not right. That's not fair. That's not believable. In Harbin's deposition, he was asked, Dr. Harbin, is it fair to say that your opinions are to a reasonable degree of medical certainty? And his answer was yes, unless I expanded upon something. That's the nature of my testimony. So the majority of symptoms, he would have been significantly better. The primary cause is the trauma. The brain injury is the primary cause. And then you get into a preeminent neuroradiologist like Snyder, who says, I don't see any evidence of vascular disease in the corpus callosum. There's a hole in the corpus callosum, and that causes cognitive issues. This is not an issue that requires more time from the court from my position. Do you have any questions, Judge?
No, I'm tracking this very comfortably. All right, Mr. Bohr, back to you.
Thank you, Judge. Very briefly. I'll leave the podium here on this side, just in the interest of time and effort. Your Honor, we deposed Ms. Maynard her deposition transcript is court record now. She's a historian. She's the source for how Mr. Maynard has, his condition has been. And she testified that he was not 100%. All right. So that'll be clear when the court reviews Ms. Maynard's testimony. Ms. Giles said that he was fine. Mr. Maynard was fine before the crash and not fine after. Well, we aren't questioning whether Mr. Maynard got hurt in this car accident. That's not the argument that we're making here. The plaintiffs here are seeking damages for his medical needs today, 10 years later, and tomorrow, and in the indefinite future. And Dr. Snyder testified that in his interpretation of the medical imaging, he can see that there are issues that are arising from small vessel disease, and there are issues that are present in the medical imaging that arise from a source other than the traumatic brain injury. And that is the entire point. And Your Honor, one last thing that I failed to mention in my initial points, Dr. Snyder's PowerPoint, and we put this in our briefing. His PowerPoint is at 80-something pages long. And there are several things in his PowerPoint that we think will be confusing to a jury. And we just think that there would need to be some, if it is admissible at all, it would need to be edited. There are several references in the PowerPoint where he puts in images of other patients. Now, I don't think he's trying to trick anyone on purpose, but they are going to be confusing to a jury because he is showing images of another patient's brain imaging, and that is going to mislead and confuse the jury. And also to the extent that his PowerPoint contains a lot of commentary about the prognosis of someone who has what he sees in the imaging. We think that these are on the borderline, if not over the border, of a causation opinion that Dr. Snyder, as far as we can tell, is not intending to give. And we would just ask the court make sure that they toe that line and that Dr. Snyder not give a causation opinion. Thank you very much.
All right, thank you. Back to you, Mr. Neff.
Briefly, Judge. So I've been doing this for 30+ years. And when a plaintiff or a spouse testifies inconsistently from medical records, you always see them cross-examined because Miss Maynard is trying to remember something that happened in 2002 or 2013 or 2015. And fortunately, she's doing the best she can. She's a lovely woman, but we have medical professionals that have certified records that examined Wentworth Maynard and said his neurological exam in 2015 is normal. So that's no reason to exclude or limit anybody's testimony. As far as Dr. Snyder is concerned, again, going far beyond what the standard would be for a treater, he prepared a PowerPoint of 81 pages. He used examples of people with serious brain injury as demonstrative, which experts are allowed to do to teach the jury. He relied on medical literature to back his conclusions that people that have substantial injuries to their corpus callosum, like Wentworth Maynard do, have poor prognoses. And Dr. King agreed with them, the defendant's expert. In fact, Dr. King agreed with the majority of the PowerPoint slide. So Mr. Boyd is not specific about what specific slides he thinks may be misleading. He hasn't identified them to us or to you today. If that's an issue, I'd say we take it up in motions in limine. But in terms of Dr. Snyder testifying about prognoses, he is relying on medical literature. He is relying on baseline imaging studies. He's comparing those things to Wentworth scans, and he's doing that based on his education, training, and experience. All 100% appropriate. And with that, I'll ask if you have any questions, but I think we're done.
No, and again, I see that this one I'm the most comfortable with of everything we've touched on today, because these were some of the things I did get to before I ran out of time. So, all right, Ms. Gower, obviously I've been passing over you all day. I assumed if you needed something, you would tell me, but anything you wish to put on the record on any of the topics we've touched on today?
Crystal just joined some snaps, so we should exclude the medical expert.
Yes, and that's, I expected that. So, All right, perfect. Any other housekeeping from the plaintiff before I give kind of my final thoughts and then we wrap it up?
I don't think so, Judge.
Okay. Any other housekeeping from the defense?
There you go.
Okay. So y'all please, again, I'm finishing up with y'all today. I've got the jury trial folks coming in tomorrow to finish up their last motions and stuff for their trial, and then we're pivoting into that trial. They're saying a week. I've already told them that seems unlikely. And so once we finish that though and get past the 4th, that's when y'all will get my attention again. But you won't know it because I'll just be back in my office digging through your stuff. So, so try to get me let's try to get the proposed orders to me. I mean, it's 30 days work for y'all? Because again, if you need more time, that's fine. It's a lot of orders.
I don't even know what today is.
I don't either. See, today is June 15th. Let's do,
This was in the case management.
okay, it's all there. Okay. So just follow the case management order.
We will do that.
Okay. The only, go ahead. Okay, I don't remember what I threw out. That's what I'm saying.
30, you said by June 26th.
So,
11 days.
we can extend that out a little bit. Let's see.
Can we get, if we can take the 30 days, and that's since a week from now, I mean, we'll do it if the court orders it. But we're pretty tired for filing replies from Wednesday.
Yeah, I'm
getting motions on Wednesday or responses on Wednesday, having to file on Friday night.
I'm gonna push that. I'm gonna push it out to July 6th. So, because I know we're gonna end up in this trial.
Yes.
Um,
I'm gone.
I know we're gonna end up in this trial. I don't think it's gonna finish by the 26th. And then I know I'm gonna be pulled into something else before the 4th. So y'all have until Monday, the 6th.
Right. Yeah.
6.
The wife remembers her recollection is different than the doctor. So
Okay, I agree with that. All right, Alexander is being kinder than I am. So,
running marathons.
let's push it out to the 13th. Because again, I know that when this trial ends, my family has already said, you got to come home, spend some time at home. And I don't want y'all frantically typing stuff in just so that I can stick it on the shelf. And that's what Alexander is realizing that I'm unintentionally doing. So for the purpose of the case management order, everything stands except when proposed orders are due. And I'm pushing that out to Monday, the 13th. Dun, dun, dun.
I feel like the 250th anniversary of the country's birth just got a lot brighter. So
Yeah. So, well, like I said, I wasn't thinking that through, that y'all were gonna have to do that over the 4th, and I'm sorry. So, so yeah, that'll let everybody go spend some time with your families. I mean, none of us retire from home to go to work. So go spend some time with those people you love. And let's just get these to me on 13th, because that's actually that's a week that we have court, but I'm actually decently open, so I'll be able to dig in. And I actually have the week after that pretty clear too, because again, that's my dig into y'all stuff time. The only thing I know I'm ready to decide on today is deposition of Persinger. Y'all go ahead and do that depo on that follow-up question. Let's just knock that off the list. You don't need to decide time and all that now, but y'all sort that out. And they said yes on that. They said they were both consenting on both of those. All right. Anything else we need to put on record before we go off record and call it a day? All right. Hey, y'all did a great job. And I know I say this all the time, but it is a pleasure being in the courtroom with such high caliber attorneys. I say it every time and I mean it every time. It is a pleasure being in the courtroom with all of you. And so I just want you to know that y'all were extraordinarily efficient today. Everything was well briefed. Y'all's arguments were great. And it was really nice. And I really, really appreciate as a judge being in the courtroom with a bunch of tier 1 operators. So, all right, y'all have safe drives. Take your folks out to dinner, and y'all have a great night. Drive safely back to wherever you're heading from here.
Thank you, Coach.